Commonwealth of Massachusetts. This court is now open. Please be seated. Good morning.
Good morning.
Good morning. Good morning, everyone. Welcome to the Appeals Court. Let me introduce the panel. To my right is Justice Grant, and to my left is Justice Hershfang. I'm Justice Shin. We will be the panel for all 6 cases this morning. As many of you know, the rules of oral argument are each side will have 15 minutes to argue, and we do not allow rebuttal in the Appeals Court. The last thing I'll say is the panel has read the briefs. We're familiar with the record, so my best advice is to get to the heart of your argument. All right, with that, we'll call the first case, Commonwealth versus, RULA Jones, case number 2024 P262.
Thank you, Your Honor. Good morning. May it please the Court, Erin Knight on behalf of the Commonwealth, asking this Court to reverse the allowance of the defendant's motion to suppress evidence. The judge erred here in determining that the officer's use of the knife to pry open the locked glove box 1/8 to 1/4 inches in order to confirm or deny the presence of a suspected firearm was not minimally necessary. Here we have an investigation into a scared pedestrian who was caught on a Ring camera. So this stop wasn't just a plate query, it wasn't just for tint, it was due to a 911 call. The officer runs the plate and is immediately familiar with the registered owner, the defendant, who has a suspended license.
Hold on one second. First of all, even assuming it was the same car, which to me requires a lot of conjecture, because so as the judge found, it was a very general description of a dark sedan. Even assuming it was the same car, there was no criminal activity that was observed. It was just driving by.
The police don't have to wait for criminal activity to actually have happened to investigate a suspicious circumstance. And what I would say here is, in looking at the Ring video, you can see that this pedestrian is scared of this vehicle that slow trolls by him. He hides in a driveway that is not his, behind a vehicle, and the vehicle goes by. As to the general description, yes, it is a dark-colored sedan with tint. But what I would say is go back to the transcript of the motion hearing, which the judge credited the officer's testimony in full, and read what he says. He says that it is a dark tinted sedan. He can tell the tint is very dark. And when he does his perimeter check some, 10 minutes after arriving on scene, he doesn't find another vehicle of that nature, whether it's within the very confines of that exact road, Almont and Arizona, I think it was, or when he starts to branch out in that V pattern of that area.
What do we do with the judge's finding that she couldn't draw any conclusions from the Ring video other than the sedan was dark colored? And we also have the Ring video.
You can use it. So the judge finds facts, but this court can also review what was presented in its whole, especially where the video evidence.
The judge said the only thing she could see from the video is that it was dark colored.
And, Your Honor, she also stated that this was a lawful stop. She stated that she credited the officer's testimony regarding the tint. There was there was a photograph of the tint put into evidence, so that was before her as well. What I would say, Your Honor, is we're dealing with reasonable suspicion here. We're not dealing with probable cause. We're not dealing with beyond a reasonable doubt. We're not dealing with certainties. We're dealing with the investigation of a 911 call that then in turn becomes more. And so here, while that 911 call may not have been for a crime necessarily in progress, it was suspicious enough for someone to call and make the report. And so here...
Let's assume we agree with you about the stop and about the pat frisk of the interior of the car. But the judge found this was a very thorough search that lasted several minutes. There was also a discussion of who the canine officer on duty was at the time. This leads the court to believe that this was more than just a search for officer safety. How do we get past the judge's finding that although she believed the testimony of the officer, she found that his intent was for an investigatory purpose and not simply for officer safety?
So, Your Honors, that's a legal conclusion, I would argue. And here you can take the facts found, again, which she expressly credited this officer, and you can come to a different legal conclusion. Intent, protective sweep, protective search, frisk, those are all legal conclusions. And so here I would go back to, again, this is a totality of the circumstances on a case-by-case basis. And so the judge found everything was proper up until the use of that knife to pry that open. But what I would also point Your Honors to is to what this officer was seeing in real time. And again, it's a case-by-case basis. And here you have the 911 call, you have the defendant being familiar with a history of firearms, a history of gang affiliation, and stops involving this officer and this defendant. He knows this defendant. The officer's outnumbered at the beginning of the stop. He followed the path of where he believed that sedan to have gone and found in the general proximity some 36 minutes after the 911 call, which 36 minutes may pique your interest, but I would also point out that in that 36 minutes, he talks to the owner of the home, views the ring video, records the ring video, looks for the pedestrian, and then looks for the vehicle.
But none of that, what you've described is how the officer spent those 36 minutes, which is obviously relevant to the officer's engagement in this investigation, but it doesn't actually have any relevance with respect to the fact that the vehicle was near the, I mean, the vehicle can travel just as far in 36 minutes if the officer is sitting on the sidewalk drinking a cup of coffee as the vehicle can travel if the officer is engaged in the investigation.
Sure, but I guess my point, Your Honor, is more towards the timing that they're still in the area, possibly still looking for that person. They haven't fled the general area. It was close enough that he...
that unlike most of the cases in which close proximity and short time add to reasonable suspicion, you're arguing that in this case, continued proximity with time that's hard to characterize as short adds to the reasonable suspicion.
I would argue it does. I would still argue the proximity absolutely adds to that reasonable suspicion. Again, we're talking about suspicion. We're not talking about probable cause. I would also point out that as soon as the car is pulled over, the defendant in the passenger seat leans towards the front dash area. And then we have...
That's just a very general movement that was described. You couldn't see his hands. He didn't see him.
Well, that's also a problem. Not being able to see his hands is also sometimes part of the reasonable suspicion calculus.
They're not required to stay motionless.
No, they're not, Your Honor. And at no point, is the officer stating that that alone was enough. But what you have here is...
How recent were the arrests and convictions in his criminal history?
Your Honor, I don't know that right off the top of my head, and I don't believe it was discussed during, from my memory in the transcript. I don't believe it was discussed, but he does know him to have a current gang affiliation and a conviction.
We don't know if these arrests and conviction are dated. You just can't say one way or another, right?
To my knowledge, that is true, Your Honor, but I would also point out that he has them, right? And we can't expect an officer just to discredit that. He has them. He made a choice. He made a choice to carry an unlawful firearm, and for those choices, that now adds to the reasonable suspicion argument. Here, both the driver and Mr. Ilm were not licensed at the time. The driver had a concealed knife on him. The key fob was noticeably broken off. I'm sure we will speak about that. The glove compartment was locked, and this is all under the guise, or under the the review of a trained officer with experience in hides, with experience multiple hundreds of gun arrests. Even if this court were to find that these things piecemeal do not add up, the totality of the circumstances here absolutely does. And we have cases just out of this court most recently, like Ortiz and Daniels, which were 128s, but they're very much along these same lines. And this case fits squarely in with Graham, where the locked glove box was accessible. Now here, I would state that you have that movement towards the glove box. You have him not holding anything when the officer comes. You have Mr. Brown, the driver, in the center console to get the registration, not in the glove box. You have the recently broken off key. So let's talk about that.
You keep saying broken off. I don't understand that. The judge didn't find it was broken off. She found it just wasn't in the fob.
So what you could So watch the videos, Your Honor, is what I would say. The videos, the body-worn camera videos make it quite clear, and the officer's testimony, which again, the motion judge credited in its entirety, states that he believed it to be a recently broken off. There was no dust or grime or dirt in the area.
Right, but I guess I'm quibbling with your characterization of broken off. It was found on a key ring.
But it was not connected to the fob. And, Your Honors, I think you can take judicial notice of generally how the fobs are. I think this judge did.
Yes, I looked at my own fob, and the key just pops out. It doesn't get broken off. And it was found on a key ring, which suggests that it wasn't broken off.
Well, and that's what he describes, because I had the same question, and so the motion to suppress testimony, the officer very clearly describes, and again,
he uses his own.
I didn't know that you could do this until recently, that all of those key fobs we all use to click, they have an actual key inside them. You just need to pop them open, then you can take out the key. And so, as Justice Shin says, that's what had been done here. So broken off seems a little incendiary in this circumstance.
Well, you could describe it as broken off or taken out, I suppose, if you'd like to do that. But this officer described it as broken off, and that's how he felt it had been done. This is also in light of and coupled with the defendant leaning towards that area, that glove box now being locked. So if you look in Graham locked defendant Kynes in Graham locked that glove box as police were approaching. That is what we have here. Whether or not...
Well, that defendant refused to stop reaching down in between the seat when told to do so by the officer.
Defendant Kynes did, yes.
Right, there are additional facts in Graham that are not present here.
There are additional facts there, but again, this is a case-by-case basis, and you have different additional facts here. He is in the process of investigating this 911 call. He is in the process of knowing both of these defendants and their records. He is in the process of having seen that as soon as they get pulled over, the lean down. He is in the process of seeing a knife on this driver. He's in the process of knowing that at this time, even though the driver and Mr. Jones had been exited, Mr. Jones was likely to get back in that vehicle because at the time he was not arrested. A plethora of case law in this Commonwealth talk about the ability to do a protective sweep so that if someone getting back in the vehicle does not have the ability to effectuate a hidden weapon. And here we know whether it's broken off or taken off or anything like that, the key was on the defendant. So him getting...
They didn't know that.
They come to it, Your Honor, and I don't think it takes away from it. It takes away from it at the time maybe that he tried to pry it open, but where would that key be except for it's locked and on the defendant who owns the vehicle?
On the body camera footage, they say, oh, they threw it out the window or they thought it was on the driver. Didn't they search the driver for it? And the difference in Graham is that the driver was actually seen locking the glove box, and then the key was sitting right there. It was accessible to any of the rear passengers who were still in the car. Here, they don't know where the key is. They search for several minutes. They search the back seat. They search the driver. Ultimately, this was a stop for excessive tint, and the judge found that at some point, it just goes beyond a protective sweep. And how do we find that to be clearly erroneous?
We find that to be clearly erroneous because of the factors I have laid out, and also the fact that, again, this defendant has the ability to effectuate that opening of that glove box. And I would state, Your Honors, that this is in line with Graham because the locked glove box rose suspicion where this defendant was reaching towards that area, the registration was outside of it, and I implore this court to recognize that the officer safety standard is low. This court and the courts of this Commonwealth have forgotten the actual realities of the police and what they're doing. Just this past Thursday night, an officer was shot on duty here in Boston. This fear is real. The need for officer safety and to protect these officers while they have these suspicions of a firearm in a vehicle in which a defendant known for firearm and gang activity is going to get back in, the use of trying to make sure that that defendant or the woman who comes to pick up that vehicle is not going to retaliate against that officer, especially in light of, again, Your Honors, the 911 call in which this car, or what he believed to be this car, is seemingly chasing or stalking this man that looks scared. I would implore Your Honors to watch the video, take this in the totality of the circumstances, understand the officer's training and experience, and understand that while there could be innocent explanations for these things, they still add into the reasonable suspicion calculus. And here, what we have is a totality of the circumstances in which an officer very well could have been looking at a bullet had he not done what he done. And so I would argue to this court that in the totality of the circumstances, crediting the officer by the judge, the legal conclusion at the end was just wrong, and here you can find differently.
The judge, at the very beginning of her final paragraph, wrote, "In the case at bar, should the officers have found the keys first, arguably it might have been permissible to use those keys to open the glove box, which is large enough to contain a weapon." Do you think that's a legally relevant distinction?
I absolutely do. I think it's legally relevant because she's basically saying because the defendant obfuscated the key, you now don't get into that glove box. I think that's entirely appropriate that she thinks you can get in that glove box because under Graham, you can. Under Pagan, you can. Things you can't reasonably frisk can therefore be opened. And so here, finding that glove box legally could be opened, but couldn't be because of the defendant's behavior, squarely is in line with our interpretation of the totality of the circumstances that it was lawful.
How do you link it to the defendant's behavior? The judge did not find that the defendant hid the key or broke off the key, and nor did the officer testify that he did.
Your Honor,
There's no
if I may.
testimony. Yes.
The officer did testify to his thoughts regarding the key and that it was broken off. I will point
He never said the defendant, there is some reason to believe the defendant hid the key. He never says that.
He says that page 39, the key fob was found in the cup holder. The actual physical key was missing. Page 40, the key looked to be recently removed. No dirt, no grime, nothing to show it had been missing for a while. And Exhibit 3 is a picture of that key. So he does testify to that.
I mean, in your briefing today, you've said multiple times that the defendant obfuscated the key or hid the key. And that's a factual finding, right? I mean, I don't see that anywhere, either in the judge's findings or in the testimony.
So that is what the officer was acting under. That is what his thoughts, his reasonable suspicion was. Should this court not credit that, that is fine.
He doesn't
I understand
say
what you're
that.
saying, that
Yeah.
the judge didn't credit that. So what the court can
No,
then
what I'm
do-
saying is the officer did not say the defendant hid the key, right? At first, they thought it was the driver, right?
It could have been one of them, but it doesn't matter which one it is. There was a weapon already found on the driver, so that would then lead to another reason for the protective search of looking for any other weapons that could be found in the car. And again, that's under the case law. And if I may just finish, I would state that, Justice Hershfang, to your question, finishing out your question, the key fob was there, so they did have that key. They just didn't have the actual access in because of it not being present. So even if the key's not present, it's broken off, what have you, it was still legally sound to get into that glove box, and the minimally way necessary to do that, because they didn't have that physical key, was to look in with the knife so that they could then let the defendant be on his way, as he was not yet arrested.
Okay, thank you.
Thank you, Your Honors.
May it please the Court, James McKenna for Mr. Jones. Good morning. Usually I sit over there and argue that the judge got it wrong. This time I've got the privilege of sitting over there, arguing that the judge got it right, and the judge did get this right. At some point, what had been a protective sweep became an investigative search. As the judge found, as a matter of fact, this was a hunt for evidence. And as such, it surpassed what was permissible under the reasonable suspicion standard. That's all they had. What was constitutionally offensive, what the judge found to be constitutionally offensive, was prying open the glove box. Shining light in there, apparently, the officer testified he illuminated this as he did so, and looking for evidence. As the judge below found, that was to find evidence. That wasn't for protective, that wasn't a protective sweep.
Prying? Was it the act of prying that was a violation, or was it the act of opening the glove box?
Prying. The judge,
So if the key had been sitting there next to, accompanied by the fob, you maintained that it would have been lawful for the officers to open the glove box?
the judge didn't reach that. We don't.
No, I'm asking you.
We don't suggest that it would have been unlawful. If
Why is that a difference?
Because they committed a violation in sequencing. By prying open that glove box looking for evidence as opposed to looking for the key. If they had searched Mr. Jones and found the key, this case would have been a lot closer to Graham. Because now they've got the key as they had in Graham. And now if they open the box, the judge might not have ruled as she did. But they didn't. It would be as though someone were taking the Miranda warnings out of sequence and getting a statement and then providing the warnings. This was, they did the illegal search before getting the key, which goes to one of the facts which underlies why this was illegal. In terms of how this could have been a problem by letting them back in the car, it wouldn't have been if the glove box is locked and they don't have the key. As Your Honor mentioned, they did a thorough search of the car. There was no key.
What if the gun was in a hard-sided suitcase that zipped closed but was not locked? Would the unzipping be improper? Why is what is it about the prying that's improper?
The judge found that was just going too far. If they had the key, they could open it and that's okay. Prying it, they spoke about marks, pry marks on the glove compartment box and how there were none. If you're breaking things, if you're prying things open, that's too far. That's what the judge was saying here.
So what about unzipping a hard-sided suitcase?
That goes to what we spoke of in our brief about the inventory searches. If it's a non-investigative search, you don't open the suitcases. If it's an investigative search for inventory search purposes, inventory sweeps purposes, not investigative searches, then you don't do that. There's case law on this we have in our brief saying that.
What about the fact that if the police let them go on their way, anyone who's in the car can unzip the hard-sided suitcase and get the gun?
And if you're right, that's correct. And if it's a locked suitcase, that's one thing. And that's kind of what we have here. It's a
My hypothetical was an unlocked, zipped, hard-sided suitcase.
we would have a much weaker case if the glove compartment had been unlocked, or in that scenario, in that hypothetical. If it's unlocked, now we don't have the situation where if you put them back in the car and they don't have a key, no one can get into the glove box. If they didn't have the key anymore.
But the question is whether it's reasonable to believe that the defendant could readily access a weapon from the area being searched. So in Justice Grant's hypothetical, if it's a suitcase that's sitting there, all you have to do is unzip it, you could readily access it, right? So let's say it's a locked glove box. Why couldn't the officers reasonably believe that maybe the key is on the defendant, the person of the defendant somewhere?
They probably could have reasonably believed that. And if they had searched him before prying open the box or prying open the glove box a little bit, they would have had a case much closer to Graham than we are. But they didn't. And that's what they got out of sequence. They committed the constitutional violation by prying open the box, doing a hunt for evidence, as the judge below found. If they'd if they searched for the key first and found the key and used the key, now we're pretty close to Graham. But they didn't. And that's the distinction.
Do you concede that the sweep of the car was itself proper?
We don't contest that.
You don't contest it?
Yes, Your Honor.
Meaning you concede it was proper to
Yes,
sweep
Your
the
Honor.
car?
Yes, Your Honor. Yes, Your Honor. We don't contest that. All we're saying is it was wrong. It was going too far to pry open the glove box. And that's kind of where we are. So unless the court has any further questions, I'll try to find where my proper seat is. And thank you very much.
Thank you. Thank you both. The case is submitted. All right, the next case is Commonwealth versus ALEC Butler, number 2024 P1381.
Good morning, Your Honors. Luke Roseal for ALEC Butler, and may it please the Court. The Commonwealth wants this Court to break new ground by upholding a negligent vehicle homicide case on less evidence than has ever been previously deemed sufficient, and by upholding a consciousness of guilt instruction on bases that have previously been deemed inappropriate. Mr. Butler respectfully requests that the Court not break that new ground in this case. Starting with the first issue, the first fact that I want to emphasize from the record is that Mr. Butler, and I want to recognize Mr. Butler is in the courtroom in the gallery watching today's argument, pressed the brakes of his vehicle at least 1 second before the impact with the tree and as much of just shy of 1.5 seconds before the impact with the tree.
What do we do with the trooper's testimony that for 5 seconds before the airbags woke up, is how I think how he put it, there was no braking and the accelerator was slightly depressed, and the SUV was decelerating because it was driving over boulders?
So I think what we do with that testimony, Justice Grant, is we have to scrutinize it carefully. And we see that's at page 132 of transcript volume 2. And when we go back to page 131, what we see there is that the officer is describing record 3. Right, there were 3 records from the airbag control module, and on page 131, the officer clearly says record 3 is leaving the roadside and beginning to hit the rocks on the soft shoulder there. And so that is his testimony with respect to record 3. But then when we look at what the officer testifies to with respect to record 1, and this is at page 140, that's where the officer testifies, Lieutenant, I should say, Nicoloro testifies that record 1 is the impact with the tree, and page 151, line 12 to 152, line 6, he says approximately 1 second before this particular incident, that being the impact with the tree.
So are you asking us to hold that as long as the driver brakes at some point, he's not negligent?
No, but I am asking this Court to hold that braking before the impact distinguishes this case from those cases such as Hardy, relied on by the Commonwealth, where the brake is not depressed at all before the impact. And I think what we see on record, on the Record Appendix Volume 3, page 54, is 1.5 seconds before the impact with the tree, the car is traveling 34 miles an hour, the brake is not depressed. Half a second later, the brake is depressed. At that point, the car has slowed from 34 miles an hour to 11 miles an hour, and that is a full second before the impact with the tree.
So are you asking us to discredit the Lieutenant Nicoloro's testimony that the reason that the car decelerated was because it was driving over boulders?
No, I think that is a reason it likely decelerated, but there's also objective evidence in the record that's irrefutable showing a coincidence between that slowing down and the depression of the brake. And so I think that even viewing it that's Record Appendix Volume 3, page 54, shows that when it goes from 34 miles an hour down to 11 miles an hour, that coincides with the brake being pressed. And so even viewing that evidence in the light most favorable to the Commonwealth, it's objective documentary evidence. And so I think it definitively proves that. And at page 10 of the Commonwealth's brief, when they say that the brake wasn't...
Definitively proves what, I guess? Because there's a sequence of events here, right? And you're dealing with a one-car accident with no eyewitnesses. So all we have is the reconstruction testimony. But hitting the tree was obviously the last thing that happened.
Correct.
But there was the driving off the road, there was running over multiple boulders, there was running over multiple boulders while apparently still accelerating for at least part of the time. So I guess that brings me back to Justice Grant's question. Is it the fact that he did finally brake? Are you arguing that is enough to take this out of the realm?
I'm saying that certainly distinguishes this case from Hardy, and I would push back respectfully, Justice Hershfang, on continuing to accelerate after it leaves the roadway. I think if record 3 is leaving the roadway, there is no continued acceleration from that point going forward. And so the other two things that I would stress from the airbag module data are that it shows that there was just more than 1.5 seconds from the time the car left the road to it hit the tree. So it's a very small sequence of events, very
What do
short.
you say to the Commonwealth's argument that if a marked lanes violation is evidence of negligent operation, then leaving the roadway altogether is?
I'm saying that certainly distinguishes this case from Hardy, and I would push back respectfully, Justice Hershfang, on continuing to accelerate after it leaves the roadway. I think if record 3 is leaving the roadway, there is no continued acceleration from that point going forward. And so the other two things that I would stress from the airbag module data are that it shows that there was just more than 1.5 seconds from the time the car left the road to it hit the tree. So it's a very small sequence of events, very short.
What do you say to the Commonwealth's argument that if a marked lanes violation is evidence of negligent operation, then leaving the roadway altogether is?
I'm I would say we cannot reach that conclusion based on the case law, and the case that I'd bring to the court's attention is the Osella case, where that's 406 Mass 415. There, the defendant struck 2 pedestrians at a narrowed portion of Route 99 that was not lighted due to construction. The force of the impact was great, throwing 1 pedestrian some...
But those facts are different because there was problems with the lighting.
Well, I think there's also problems with the roadway here, right? If it was just a straight road and you leave the roadway with no curve in the road whatsoever, but the facts here are that the road narrowed, like in Osella.
So did you find any cases where driving off the road at a slight curve is or is not negligent operation?
I haven't found a case that close to being directly on point. I also have not found a case with this small a quantum of evidence on which a conviction like this has been upheld. I mean, Osella, I think, is really illustrative here. There, the defendant drags a pedestrian some 60 feet, drives away, lies about the car being stolen. There's so much more evidence of negligence there.
Right. In the light most favorable to the Commonwealth, how many beers did your client have while golfing?
I believe in the light most favorable to the Commonwealth, it would be 4. And in the estimate that I do in coming to fewer than or less than 1 drink per hour, I use the maximum numbers from the testimony.
But if Sean McAndrews said he had 2 to 3 beers, and Jonathan Gould said he had 3 to 4 beers,
then we take the highest number in the light most favorable to the Commonwealth.
so isn't that 7?
No, they're on a team playing together. It's not as though I saw him at one point.
So were Sean McAndrews and Jonathan Gould in the same golf cart?
I don't know they were in the same, I don't believe they were in the same golf cart, but the way the scramble format works, and I suppose that could be the subject of judicial notice.
So there's not a chance in the light most favorable to the Commonwealth that it was 7 beers?
I have to come out with that being crossing the line into speculation, right? When people are together, one person says, I saw him do 2 or 3 beers, the other person says, I think 3 or 4 beers. The light most favorable to the Commonwealth is 4 beers.
We're at several beers at least, plus 1 more during the award ceremony.
Well, I would respectfully dispute, Justice Grant, that there's any view of the evidence that has him drinking 7 beers out on the golf course.
I think she said several.
Several.
Several, excuse me, yes.
Plus 1 more during the award ceremony.
We're up to 5.
And plus 2 more at Fireflies.
And I say 2 to 3, I take the number 3, and plus a shot of whiskey.
So in the light most favorable to the Commonwealth, he had the shot of whiskey.
That's correct.
What do we do with his testimony to the paramedic that he was coming straight from the golf tournament and he hadn't had anything to drink in a couple of hours?
I guess that is not testimony to the paramedic, Your Honor. There is a statement to that effect.
Well, his statement to the...
I think it should be discredited, right? Because if we're looking at the light most favorable to the Commonwealth, we'd take the maximum number of beers. But I do want to press on this. What we don't have anything on this record is any evidence of impairment.
Any evidence of what?
Impairment, intoxication. There's no evidence.
Isn't drinking several beers?
Not in and of itself, Your Honor.
So if
That's why in all these cases.
If your client had moved to strike the testimony of the people who saw him drinking at Fireflies and at the golf tournament, it would have been allowed?
No, I think that there's some relevance to the fact there was drinking ahead of time. But what I do want to emphasize here is we have evidence from lay witnesses, from law enforcement witnesses. Everyone agrees there were no signs of intoxication whatsoever. And so it would be a different record if there were some
But
bloodshot
no
eyes and
signs
so
of
on.
intoxication is different from no evidence of impairment.
That's fair, and we also have no evidence of impairment.
He ran off the road, and he'd been drinking several beers.
And so we get back to the severity of the argument as, the severity of the crash as itself being evidence of negligence. And that's where I have to collapse back to Osella, where it was a much more severe outcome than that. He's dragging the victim some 60 feet, flees the scene, abandons the car, lies about it having been stolen, and still that was not evidence. The other case that I would point to here is the 128, Justice Hershfang, I believe.
What do you do with Commonwealth v. Howe? It's a published case that says the accident or the damage resulting from the collision can be considered an evidence of negligence.
It very much can, and Howe is distinguishable because the defendant crossed the double yellow line into a complete opposite lane of travel, striking a telephone pole and a mailbox and spinning to strike another mailbox.
Right, but you keep talking about the facts of other cases. I want to talk about what your client did.
Yes, and so
So he ran off the road and ran over boulders.
That's right.
Without braking for 5 seconds.
Well, the 5 seconds preceding before he went off the road. And I think the other fact, even taking in the light most favorable to the Commonwealth, is he'd navigated at least 50%, more than 50% of the curb before doing that. The severity of the accident is part of it, but if the severity of the accident can carry the day, that's in this case, that's inconsistent with Osceola.
So he doesn't apply the brakes before he goes off the road.
I think in the light most favorable to the Commonwealth,
And-
it's about contemporaneous with going off the road.
The braking was contemporaneous with going off the road. I thought, in the light most favorable, he wasn't braking. He goes off the road, and then a few seconds after he goes off the road, he applies the brakes, right before the impact with the tree.
Well, I think what we see is, from the time he left the road...
Is that correct?
From the time, I believe not, respectfully, Justice Shin. From the time he left the road to the time that impacts the tree, that's 1.5 seconds. We know that definitively. Record Appendix 3, page 52, has 0.807 seconds between Record 1 and Record 2. Record Appendix Volume 3, page 59, has 0.791 seconds between 2 and 3. And so in total, there was only 1.5 seconds. And what we see is...
Is that in the light most favorable to the Commonwealth?
Yes, because that's documentary evidence that...
What do we do with the damage to the undercarriage of the SUV that the trooper said shows that he was driving over the boulders and that was what was slowing down the SUV?
I think that's certainly part of it, but it has to be viewed in the totality of the evidence, which includes the objective, undeniable evidence that he pressed the brake at least a second and as much as almost a second and a half before he hit the tree, and only 1.5 seconds elapsed from the time he left the road to the time he hit the tree. If I may, I do want to just spend the last few minutes here on the instructional error, unless there's other questions on that. And what I want to emphasize...
I do have a question. I don't understand where you're getting the 1.5 seconds. In your brief, you have this chart that has 5 seconds. What does the 5 seconds represent?
The 5 seconds, each of the 3 records records data from the 5 seconds preceding the record. So Record 3 records data from the 5 seconds before he left the roadway.
Where does it say before he left the roadway?
Certainly.
The Lieutenant Nicolora said it was before the airbag system woke up.
And what he said, when what Lieutenant Nicoloro said for the airbag system waking up on Record 3 is at Transcript 2, Volume 2, page 131. Record 3 corresponds to, quote, striking the rocks. I believe that was the object that it hit, the rocks that were on the soft shoulder, just beside the roadway there. And that caused the initial wake-up of the airbag. So in the 5 seconds preceding that, the brakes were not pressed.
But so for some amount of those 5 seconds, the SUV is traveling over rocks and the brake is not being pressed.
I would push back against that. Once the vehicle hits the rocks, that's what wakes up, Lieutenant Nicoloro's testimony, that's what wakes up the airbag and puts that prior 5 seconds into the module unit. There's no testimony about Record 2, what that is, but we know that there was 0.791 seconds between Record 3 and Record 2. That's Record Appendix 3, page 59. We know there was 0.807 seconds between 2 and 1. That's Record Appendix 3, page 52. And you add the two of those together and you're just north of 1.5 seconds.
So he's not braking when he goes off the road, right?
I think in the light most favorable to the Commonwealth, he goes off the soft shoulder.
And he's not braking. He goes right off without swerving or braking.
Without swerving or braking, after having navigated half of the curve.
So this case does seem pretty similar to Hardy.
Hardy didn't brake before the impact at all, right?
Right,
That's a sizable distinction, and there were other distinctions in Hardy as well, which I do articulate in the brief, I believe, the distinctions with Hardy. That being said, I think the fact that we're arguing this energetically about the sufficiency of the evidence at least goes to the instructional error that it is not overwhelming evidence here, right? This is not a person fleeing the country to Peru, like the Commonwealth's case. It's not a person fleeing the scene.
What if we agree with you that there wasn't sufficient evidence of flight? What about his false statements to police and paramedics?
And I understand, Justice Grant, that this court can uphold on a different basis than the one being argued by the Commonwealth. That's a different basis than the one being argued by the Commonwealth. But what that doesn't get you past is part of what was on the court's mind here was reaching out to counsel. Part of the big argument the Commonwealth was making below was that leaving the hospital was tantamount to refusing to provide a blood sample, and there's ample case law saying you can't draw a negative inference based on refusal
What about,
evidence.
can we draw a negative inference from his statement to the paramedic? Are you going to take my blood?
If that's all there was, Justice Grant, that might be an appropriate basis for you to uphold the inference, but because it is so polluted by the other basis.
What do we do with the evidence that 2 days later he went to a different hospital for treatment of his injuries?
May I have a moment to, and let me,
Yes.
I don't see that as any evidence of consciousness of guilt. That seems like a very stretched, and I also certainly don't see that as any evidence of negligent driving. If a person has to have on their mind, gee, should I go to the hospital? Well, it might be used against me in a court of law if I go to the hospital. That's not the purpose of having consciousness of guilt inferences. And so you had to speculate here. It was based on refusal evidence. It was based effectively on like invocation of counsel, reaching out to counsel, and for those reasons, and the evidence was far from overwhelming. And for those reasons, we would ask that judgment be entered for the defendant, but at least that he be provided a new trial where the instructional error would not occur. Barring any further questions, I'll rest on the briefs. Thank you, Your Honors.
Thank you.
Good morning, may it please the court. My name is Emily Walsh, and I'm an assistant district attorney from Middlesex on behalf of the Commonwealth. Viewing the evidence in the light most favorable to the Commonwealth, there was sufficient evidence for Justice Spring to find the defendant operated negligently. The defendant failed to navigate a slight curve on a clear day. The sun was out. The defendant struck a tree with such force that all of the vehicle's windows shattered. The airbag was deployed. There was substantial body damage and damage to the tree going up 5.5 to 6 feet with glass embedded in the tree. There was no evidence of obstacles in the roadway. Turning to the evidence of alcohol consumption, the evidence is that the defendant was drinking at the golf course, but I would draw Your Honor's attention to his consumption for approximately an hour and a half prior to the crash at the Firefly, where he consumed both several bottles of beer and shots of whiskey. And you can see the
Say shots of whiskey, plural?
shot.
Is
He
that-
had
okay.
shots with his friend. The evidence is the defendant consumed one. You can see him on the video. It appears, I mean, you can't tell what's in the glass, but it appears that he drinks a shot.
People don't do shots of water generally.
It would not, that would not be an inference in the light most favorable to the Commonwealth. So just prior, in the hour and a half prior to the crash, he consumed whiskey and beer. As Justice Grant pointed out, he denied that he had consumed alcohol in the hours immediately prior to the crash, which is not accurate. And that it is reasonable to infer that he knew his alcohol consumption could have contributed to the crash, and that's why he told that lie. Turning to the hitting of the brakes, Reconstructionist Niccoloro testified that pre-impact there was no braking. Quote, there was some brake activation during the sequence of when it was hitting the rocks. When it was bouncing around at some point in those sequences, yeah, the brakes are applied. That is on transcript 2, page 151. So
In the light most favorable to the Commonwealth, how would you characterize the evidence on braking? So when did the braking occur?
It appears that the braking occurred immediately in the 1.5 seconds prior to hitting the tree, as he's losing control and the car is hitting the boulders. So he was hitting the brakes after the crash was already occurring. He had not come to rest against the tree, but according to Trooper Niccoloro's testimony, it was as the car was hitting the rocks, he was braking.
So how many seconds between going off the roadway until hitting the tree?
Lieutenant Niccoloro didn't specifically address it in those words, tying the event to the time, but looking at the pre-crash data charts, so those are all overlapping, right? It starts at the highest speed is 37 miles per hour going to 0. He accelerates at between 4 seconds prior to stopping and 2 seconds prior to stopping. There is acceleration. He's going 35 miles per hour at 2 seconds prior to the stop. 35 miles per hour and pressing the accelerator 2 seconds prior to the stop. At 1.5 seconds, he is no longer pressing the accelerator and it slows to 34.
There is then, I'm looking at RA 354, which is record 1 of the pre-crash data. He goes from 34 to 11 miles per hour in half a second, and that is when the brake is activated, which according to Trooper Nicoloro's testimony is as it was hitting the rocks, bouncing around. At some point in those sequences, yeah, the brakes are applied. So it appears that that abrupt change from 34 to 11 miles per hour in half a second is as the car is hitting the rocks, and that is why it's slowing down. The rocks were described as quite large boulders lining the roadway, and then they were displaced. So it was obviously significant impact on the car, and the car itself showed that impact. The fact that the brakes were applied as the car hit the rocks 1 second prior to stopping at the tree does not tend to show a lack of negligence. Are there any further questions on the negligence issue?
So if I can just trace that back, is it the Commonwealth's position, and I know you don't need to specify this for trial and certainly not for us either, so I'm just trying to get a sense. Is your position that the negligence sort of occurred or at least began at the moment of leaving the roadway?
No. The negligence started when he consumed a lot of alcohol that day and several units of alcohol prior to getting into his vehicle and driving. I would suggest that that is evidence of negligence under the case law. And the negligent operation, there is testimony to negligent operation earlier in the day. The testimony from Jonathan Gould, the defendant's friend who went with him to walk his dog. This was several hours prior to the crash, but it is still relevant as testimony. Jonathan Gould testified that he put on his seatbelt while driving with the defendant because he, quote, noticed a change in the defendant's driving behavior. That's on transcript 2, page 52 to 53. So in addition to the consumption of alcohol and his friend's testimony, you have the fact that he drove off the road into a tree with all of the elements that I opened with, that it was a clear day, a straight curve, the force of the crash, the lack of evidence of obstacles in the roadway, all of that tends to show negligence.
How do you distinguish Acela?
I'm sorry, could you, which case?
Acela, I don't know if that's how you pronounce it, but
Acela was, so there were 2 pedestrians were struck by a car as they attempted to cross Route 99 in Everett. I'm not really familiar with that area of what that street is like, but it seems like it is possible that it is not a pedestrian-friendly road. Pedestrians are moving targets. The fact that they hit a pedestrian in that case is not similar to hitting a tree. The pedestrians could have darted out into the roadway in the dark in a way that a tree cannot, and it was a well-lit road on essentially a straightaway. It was barely a curve. The pictures are in the appendix. One of the witnesses declined to call it a curve. I think Acela is easily distinguishable from this case. This case is, I would suggest, closest to Woods. Are there any further questions on negligence? Briefly regarding the consciousness of guilt instruction, the Commonwealth properly requested the instruction for consciousness of guilt based on flight, where the defendant left the hospital against medical advice after 45 minutes of waiting. The evidence for consciousness of guilt need not be conclusive. A consciousness of guilt instruction is permissible even if the defendant's actions have an innocent explanation. And in this case, even if there were an error related to the instruction, there was no prejudice to the defendant, where the judge stated on the record that she did not find the evidence of flight to be compelling evidence.
But do you agree it would have been error to find consciousness of guilt based on his reaching out to an attorney?
Yes, I do.
So the prosecutor articulated that as one of the reasons for a consciousness of guilt instruction, and the judge did not say she wasn't going to rely on that. I mean, she said that she didn't find the evidence compelling, but she says, I will consider it. So what do we do about that?
So the prosecutor originally moved saying, I'm moving for this based on flight. He did mention the call to the attorney as one of the reasons supporting it, which the Commonwealth concedes is not a proper basis for a consciousness of guilt instruction. But the judge is presumed to know the law. The fact that she did not clarify on the record that she was not going to consider that does not mean that she accepted that as consciousness of guilt. And the fact she says, so I'm not saying that I find that evidence to be at all compelling. I'm going to consider the instruction, but I'm not saying what I'm going to do with it. She clearly didn't find it was compelling evidence of guilt, and there was ample other evidence of guilt for her to rest her verdict on.
Well, where the evidence isn't, let's say it's not overwhelming for the Commonwealth, could that not have made a difference?
I don't think that for a consciousness of guilt instruction it would make any difference. I couldn't find a single bench trial case discussing error with giving consciousness of guilt, but I would draw your Honor's attention just to the consciousness of guilt instruction itself. So the consciousness of guilt instruction says, if the Commonwealth has proved that the defendant did flee, you may consider such actions indicate feelings of guilt by the defendant, and whether in turn such feelings of guilt might tend to show actual guilt. And again, the judge essentially said, I find that uncompelling. It goes on to say, you are not required to draw such inferences, and you should not do so unless they appear to be reasonable in light of all the circumstances of the case. Most of the model instruction says things like, please bear in mind that a person having feelings of guilt is not necessarily guilty in fact. It is not an instruction where a judge sitting in a bench trial who considers evidence of guilt, where that is likely to have prejudiced the defendant in any way. It is, much of the instruction is defense favorable. And she stated on the record that she did not find it compelling. It is clear from the record she gave very little weight to flight, and the case law makes clear that if there is evidence of flight, which there was, it can be given, and the evidence of flight does not need to be conclusive, and the instruction is permissible even if the defendant's actions has an innocent explanation. It was within the judge's discretion to instruct herself on consciousness.
I understand the Commonwealth's argument in the trial court and here seems to be focused on flight as consciousness of guilt. Why hasn't the Commonwealth ever argued about false statements to police and attempts to conceal evidence?
I don't know why that wasn't argued at trial. It was fleeting in the trial transcript, so perhaps it wasn't heard at the trial.
It was what?
It was relatively fleeting, like the statement to paramedic Snee that he had not had a drink in a couple of hours. Perhaps that was missed at the trial level. But because it wasn't highlighted to the judge as a basis for the instruction, I did not argue it in my brief either.
So does that mean that the judge couldn't consider the
No,
evidence?
the judge certainly could consider the evidence. It's just that she didn't make a specific note about it. It was evidence that was admitted at trial with no objection. It was certainly something that could be considered towards the defendant's guilt.
What do we make of the fact that the defendant said he hadn't had a drink in a couple of hours?
I think
And it just so happened that outside of Fireflies, he ran into a retired Marlboro firefighter.
I don't know what to make of the firefighter, but I do think it is reasonable to infer that the defendant knew that his alcohol consumption could have contributed to the crash and that would be a reason for him to lie to paramedic Snee about having not had a drink in the last few hours. And I think that could be considered evidence of guilt that the fact finder considered. If there are no further questions, I'll rest on my brief.
Okay, thank you very much. Thank you both. The case is submitted. The next case is Commonwealth versus Ferris, number 2024 P1275. When you're ready.
Good morning, and may it please the court. Defendant Fuad Ferris was convicted of involuntary manslaughter and reckless motor vehicle homicide arising out of the tragic death of his rear seat passenger in a motor vehicle collision which occurred on a straightaway of a two-lane road in Worcester on the early morning hours of October 10th, 2021. On this direct appeal, Ferris argues that the evidence was insufficient to support his conviction on those charges, and in the alternative, that those convictions were duplicative. As the Commonwealth recognizes, the SJC, in recently reaffirming this court's decision in Najuna, has reestablished those two convictions are duplicative. So I'm going to focus on the sufficiency of the evidence issue. And that's an issue which, as the SJC put it in Carter, is entirely fact-specific. There's no case just like this one, and the court really needs to look at the facts of this case, in particular the sequence of events, in order to determine whether the elements of those two very similar offenses, whether there was sufficient evidence. And in that regard, I submit that the critical evidence, which is before this court, consists of the video, which shows the sequence, which it's Exhibits 4 and 31, which have been submitted to this court on a thumb drive, as well as a number of still photographs, which in particular show the tire marks, the oversteering marks, which occurred when Ferris lost control of his vehicle. So, taking the evidence in the light most favorable to the Commonwealth, here's what the jury could have found. They could have found that Ferris was driving his vehicle at approximately 2 a.m. On a two-lane road in Worcester. The road was dry, the lighting was good. The jury could find that Ferris was racing another vehicle, and that in racing another vehicle, Ferris drove on the wrong side of the road for less than a quarter of a mile, speeding, and then at 54 seconds of the video of Exhibit 31, he got back into the correct lane. And shortly after passing a crosswalk...
I'm not sure that he got back into the correct lane as part of the light most favorable to the Commonwealth.
Well, Your Honor, I think the video is very clear. Even the Commonwealth's witness, Julia Baumann, whose car he struck, said that prior to the collision, he came back into my lane. And the tire marks, which are attached to in the appendix as Exhibits 19 and 20, they show quite clearly that he lost control on the straightaway 42 feet after the crosswalk. Both the Commonwealth's expert and the defense expert both agreed there was no evidence that the defendant had lost control of his vehicle prior to those tire marks. So I don't think there can be any dispute that he was in the right lane when he lost control of his vehicle, swerved back into the left lane, and struck an oncoming vehicle.
By the left lane, you mean oncoming traffic.
I'm sorry, Your Honor?
By the left lane, you mean oncoming traffic,
Right,
because this is one lane.
Clearly, the collision occurred. He was in the wrong lane when the collision occurred, but before the collision occurred, he had been in the right lane, the correct lane, driving on a straightaway, and then just after a bump in the road, 42 feet after the crosswalk, according to the testimony, he lost control of his vehicle by oversteering and swerved into the wrong lane. And that's where the accident occurred, and that's what caused the accident. That is the sequence of events. And so now, looking at the legal standard, starting with involuntary manslaughter, a common law offense, the elements are obviously reckless or wanton conduct and proximate cause. And those are both important elements in this case. With respect to reckless and wanton conduct, the conduct must be such which created a high likelihood of substantial harm to another. It has to be far more than gross negligence. And I think the SJC's decision written by Justice Seifer, former member of this court, in Hardy is extremely, I mean, there's a bunch of cases, obviously, on involuntary manslaughter, but Hardy is particularly instructive because one of the things it says in Hardy is that the defendant had to knowingly decide to assume that risk, the high likelihood of causing substantial harm to another, rather than alter his behavior. And in this case, I'll argue when I get to the application, that's precisely what Farris did. He altered his behavior. He was driving in the wrong lane, he was speeding, he was racing, then he altered his behavior. He went into the correct lane.
But he was still racing.
I'm sorry, Your Honor?
He was still racing at that moment in time.
Well, at that point, he had gotten in front of the other car. He was in the correct lane, and whatever he was doing at that point did not, I would say, create a high likelihood of substantial harm to another.
He's speeding. I mean, if he wasn't speeding, I don't think hitting a bump in the road would cause you to careen into the opposite lane.
Well, the evidence was, I think that at the time, the closest evidence about his speed was something like 51 or 52 miles per hour.
I think it was
according
between
to
53 and 60.
Okay, 53. Well, the evidence by one of the officers that said 70 was stricken by the judge. Okay. So yes, he is speeding. It's a 35-mile-an-hour zone. So, I mean, look, this is a continuum. You know, where is the line between gross negligence and recklessness? I mean, that's essentially a difficult line to draw, but part of the line is in the degree of risk that is caused. I mean, in Hardy, for example, the SJC found that even though the defendant basically didn't put on her brakes and smashed into a truck, and the two children in the vehicle were not in correct seats, that was not recklessness. I mean, it's a very high standard, recklessness. And what Justice Cypher said in Hardy is you can't evaluate recklessness by the tragic consequence. You have to look in a very hard-headed way at what exactly the defendant was doing when the collision occurred. So I would say, so with respect to the recklessness element, that his conduct at 2 o'clock in the morning, once he got back in the correct lane, did not satisfy the very high standard required for recklessness as opposed to gross negligence. And then with respect to proximate cause, when he's in the correct lane and he goes over this bump and loses control of his vehicle, that does not establish proximate cause. That whatever he had been doing earlier is not what caused the collision. And this court must look at proximate cause separately as a distinct element. So because there was a break in the causation. And it was not a natural and continuous sequence. Once he got back in the correct lane, before he lost control of the vehicle, that was a break in the sequence. And based on that break in the sequence, the causation element, the proximate cause element is not satisfied. And therefore, and with respect to motor vehicle reckless homicide, the elements are essentially the same. The proximate cause element is identical, and the language of recklessness is slightly different in the case law than under involuntary manslaughter, but it's essentially the same. It's a much higher standard than gross negligence. It requires a high likelihood of substantial harm. You look at all the circumstances, including it's 2 o'clock in the morning, nobody's really around, he's in the correct lane at the time he loses control, and taking all of that together, I would submit he doesn't satisfy the elements for motor vehicle reckless homicide, just as it does not satisfy the elements of involuntary manslaughter. Are there any questions? I thank the court.
Okay, thank you.
Good morning. May it please the court. Donna Marie Heron, Assistant District Attorney representing the Commonwealth. I just want to acknowledge that the victim's family is watching the live feed of this argument. There was more than ample evidence to sustain the defendant's conviction for involuntary manslaughter here. Looking at the light most favorable to the Commonwealth, which I suggest my brother is not doing, is that this defendant was driving more than twice the speed limit. The speed limit's 30 miles an hour. That was testified to by the two officers, Farrakko and Garlick. And that he's driving almost twice the speed limit in the wrong lane while he's drag racing his friend. The evidence does not show, I suggested, he came into, looking in the light most favorable to the Commonwealth, that he was driving in the correct lane of travel. And I suggest you look at Omar's testimony, his friend who he is drag racing, at pages 53 through 54 and 70. He specifically says, no, the defendant was still next to me when the crash occurred, and at the last second he was trying to get ahead of, he was trying to go back into the right lane of travel, but wasn't able to. Officer Garlick, in his testimony, said he was looking at the surveillance, and I suggest you look at the surveillance videos, Your Honor. At most, at the last second, he's able to get into the correct lane of travel. I don't think the video shows that. I've looked at it numerous times, but I would suggest it's ambiguous as to whether at the last second he's able to go ahead of the car in front of him, but regardless, drag racing behind the Worcester Police Station, going nearly double the speed limit, traveling in the wrong lane of travel, quite frankly, is wanton and reckless conduct that supports his conviction. I ask this court to affirm his conviction of involuntary manslaughter.
In the defendant's reply brief, at page 11, he writes, significantly, the Commonwealth does not dispute that if the defendant were in the correct lane at the time he lost control, the improper conduct he had previously engaged in by driving at an excessive speed and on the wrong side of the road did not proximately cause the victim's death. Do you agree with that?
I could wholeheartedly disagree with that, Your Honor. The fact that he's drag racing his friend, and also there are cars. If you look at the beginning of the surveillance video, there's clearly other cars behind the defendant, and there's a car that passes at the, he stopped at a light first, and there's a car that clearly passes in front of him in the light. And then him and his friend go to the next set of lights. Omar gets out of the car, runs to the defendant, then the defendant goes into the left lane, Omar stays in the correct lane of travel, and they take off from there. But for the defendant's drag racing at that time in the wrong lane of travel, this accident would not have occurred and the victim would not have died.
Did you find any cases specifically about drag racing being involuntary manslaughter? I think I remember one from my law school criminal law casebook, but I might be hallucinating.
Not drag racing per se, but D. Simone, which is an old 1965 case, and it's with the girl's car and the guy's car, and they're kind of going up, they're passing each other, weaving in and out of traffic because the car full of the guys are trying to catch up with the car full of girls, and that's the best I could find closest to it. I would suggest out of this court in SJC, Commonwealth Chiguna, where you're speeding, switching lanes, and tailgating is not even as egregious as this, and this court and the SJC concluded that constituted wanton and reckless conduct. Certainly drag racing on the wrong lane traveling nearly double the speed limit, which Omar testified he was going 60 miles an hour and the defendant was able to pass him. So we have him at least going 55 to 60 miles an hour in a 30 mile per hour zone behind a Worcester police station. Quite frankly, is as wanton and reckless as it gets, and I ask this court to affirm the defendant's conviction of involuntary manslaughter, and as noted, I concede under Chiguna that the motor vehicle homicide has to be vacated and in judgment for the defendant as being duplicative of the involuntary manslaughter. If there's no further questions, the Commonwealth rests on its brief.
Thank you very much. The case is submitted.
Fine with me.
We'll hear the fourth case if the attorneys are here, which is MTGLQ Investors LP versus Kathleen Macintosh and others, number 2024 P1091.
Good morning, Your Honors. Attorney Adam Sherwin for the appellant. May it please the court. Your Honor, I represent the appellant in this case, Kathleen Macintosh. This is an appeal of the post-foreclosure summary process case from the Northeast Housing Court. My client was named in this case. She was the owner of the subject property. She was not on the underlying mortgage or on the note, but she was an occupant of the property. She was named as a defendant. We raised offenses against the eviction and the underlying foreclosure based on compliance with paragraph 22 of the mortgage and the notice to quit and summons. We contend that the court erred as a matter of law in ruling in favor of possession for the mortgagee in this case. The factual background of this case is a little bit different. You're used to seeing cases where it's the mortgagor that raises these matters, but I would suggest that our position is entirely consistent with the SJC precedent, along with this court's precedent about standing and about proper foreclosure challenges.
When you say this court's precedent, are you talking about Johnson?
Yes, Your Honor.
And how about the SJC? What's your your best SJC standing-based case?
I'm not aware of an SJC case that is just standing. I rely on Johnson. I would actually also rely on the Attorney General versus Dime Savings, which is cited in Johnson, which discusses standing based on a lawful right to occupy the property. In the Johnson case ruled that a bona fide tenant had a right to challenge the underlying foreclosure. The court explicitly said in Johnson, it doesn't matter that you're not on the note or mortgage. You're challenging it based on a defect that's void. You have a right to challenge it on standing, being that you are a bona fide tenant. As I wrote in my brief, I think a very simple hypothetical demonstrates this point. My client was a lawful owner of the home before the foreclosure sale. She chose to, let's say she chose to rent the home. She chose to do a lease with a tenant. Per Johnson, that tenant has a right to raise the same defenses that we're raising. It would follow that the owner of a person that created that tenancy would also have standing as well. And again, we contend the Northeast Housing Court got this correct. My brother, has raised it, which is why I'm addressing the matter, but I contend that we have standing.
It does seem a little bit counterintuitive that someone could raise a claim based on a contract to which they were neither a party nor a beneficiary. Do you have a response to that? And that's what your opponent argues.
Well, Your Honor, the SJC per Pinty explicitly said that the terms of the mortgage are incorporated into the power of sale requirements.
Right.
So although the defect comes from the mortgage, the SJC and Pinty very clearly said that's part of a non-judicial foreclosure process. And again, it's an error that's void, not voidable, void.
If Pinty had said voidable, which 3 justices thought it should be voidable, would your client have standing to raise it?
I would say no, Your Honor. I would say actually I believe that there are a number of potential challenges that only the mortgagor could raise against a foreclosure, but our challenge is not based on that. We're raising a paragraph 22 challenge, which again every decision has ruled is void as a matter of law noncompliance. Turning to that issue, turning to the paragraph 22 issue, the fatal flaw in this case, and just to recap, the bank in this case, the mortgagee, used the standard mortgage. They used the standard mortgage, which includes a paragraph 22 requirement. It comes with a number of disclosures. The fatal flaw in this case, the fatal mistake that the mortgagee made, was that they made reference to a right to assert in the foreclosure proceeding. It's fatal because there was no foreclosure proceeding. They chose to do a non-judicial foreclosure. Putting that in there defeats the entire purpose of the notice. It suggests that there's an avenue available for it to assert these rights that just doesn't exist.
Well, I think you're leaving out language that's important, right? And what happened here was sort of a funny amalgamation of things. So the notice says you have the right to bring a court action to assert the non-existence of a default. So that language, which is necessary under Pinty, was there.
Yes.
It then goes on to say the right to assert in the foreclosure proceeding the non-existence of a default, which is the language you're challenging, right?
Yes.
So is your position that by putting both of those things in there, it confuses the Pinty notice in a way that makes it inadequate?
Yes, Your Honor. The second you mention that, the whole purpose of the paragraph 22 is thrown out the window. The purpose of paragraph 22 is to tell that borrower, you have one shot to raise these rights. You need to bring this court action. Once you inject that and say there's a possibility of a non-existence foreclosure proceeding, that whole reasoning goes out the window. And I'll refer this court to the Aubrey versus Celine case. Both of us discussed it. It's from the First Circuit. I think it's an on-point case in which the panel does a very good job of noting the problems of that. The panel in that case notes that once you give them that right, once you suggest that you can bring the possibility of that there might be a possibility of a foreclosure case, a borrower, especially a pro se borrower, is going to say to themselves, hey, I have an option now. I can either bring my own court action or I can wait till they bring an action and just raise a counterclaim or defense. And Aubrey, I think, made a very good point about this and said that a lot of pro se parties very naturally aren't going to go on the offense. They're going to just wait till the case. Why take the time to file your own court case if one's going to come regardless? And that's a very big problem given that oncoming foreclosure proceeding is never going to happen in a non-judicial foreclosure. I also suggest that this notice has two huge problems. One is the fact that it mentions a non-judicial foreclosure in the first place. I'm sorry, a foreclosure proceeding, but the way it's written, it's put as the Justice just mentioned, the way it's written in that sentence is it suggests that some of those disclosures, some of those possible court actions belong to in a court action, and others can only be raised in the foreclosure proceeding. There's two main disclosures, two main types of actions, a non-existence of a default, and then very broadly, any other defense to acceleration or of a foreclosure sale. Reading that would suggest that the later types of action, that any defense to acceleration or foreclosure sale, have to be brought in that foreclosure proceeding, and that, of course, is not correct. You need a court action.
So if that phrase or any other defense had been repeated, both in the toward the beginning of the sentence where it talks about the right to bring a court action, and then maybe any other defense was also repeated in the right to assert in the foreclosure proceeding, they'd probably be okay.
I think they would be in a better position. I would concede that, Your Honor. But I would suggest that the way this is written is that when someone reading this would very reasonably believe that you can pick and choose between the two. I would suggest for this panel's purposes, you don't have to agree with my interpretation. This panel simply has to acknowledge, I think the relevant question is whether a borrower, whether a mortgagor could read this particular language and agree with the way that I'm interpreting it. If that's the case, that isn't strict compliance. This court's decision in Mariquin said that you can't water down the paragraph 22 requirements. You can't write it in a way where someone's going to walk away not understanding what their rights are. And I suggest the way that's written, as Justice Grant just mentioned, there is a possibility so that could happen. That's not strict compliance with the terms of the mortgage.
I thought you were arguing that the mere mention of the foreclosure proceeding makes the notice defective, regardless of the placement of that last phrase.
I'm arguing both, Your Honor. That's correct. I think my first point resolves it on its own. I don't think you even have to address my second point. The second you mentioned, the notice mentions a foreclosure proceeding for a non-judicial foreclosure notice. That's not strict compliance, and I would suggest the story is over in that regard. But I'm arguing the second point. I think it's also problematic, the placement of it, and that it seems to split the rights. This court, again, the SJC has mentioned when you bring a non-judicial foreclosure, you have responsibilities. You get the advantage of being able, a mortgagee gets the advantage of being able to do a foreclosure without filing a court action. It comes with real responsibility, and that's strict compliance. Pinty was decided the year before this notice was sent. The foreclosure itself was 2 years after this notice was sent. There's no reason that this notice couldn't have been done correctly. I want to emphasize that what we're asking the court, but importantly, what we're not asking the court. We're not asking the court to issue some order that they can't do a foreclosure. That's not correct. This foreclosure can be done properly. That's the relevant point. They have to strictly comply with the requirements, and it has to be done, assuming everything else in order. The law has to be followed, but it doesn't say they can't foreclose, but they have to do it in accordance with Pinty and the other court's decisions. I want to turn to my second argument regarding the notice to quit and summons. This was a post-foreclosure case. As with all eviction cases, it began with a summons and a notice to vacate, a notice to quit, notice to vacate. This particular matter, my client was served with a notice to quit, notice to vacate, that gave a number of different reasons about why the eviction was being brought. All of them are contradictory. At one point, it suggested that a foreclosure occurred and she was a tenant at sufferance. It also seemed to suggest that there may have been a landlord-tenant relationship between my client and the mortgagee. Also just suggests a possibility that my client may have had a landlord-tenant relationship with another entity, and that this foreclosure occurred, which would disrupt that per 186A. So the notice itself was misleading. It gave contradictory reasons about the reason this eviction was being brought.
Well, I'm not sure I agree it's misleading, but assuming that could be misleading, a tenant at sufferance isn't entitled to a formal notice to quit, right?
That's correct, Your Honor. That's correct that they're not entitled to it. The problem here is that they directly incorporated this notice into the summons as their reason.
And why does that matter, other than if there was prejudice, which I don't think you can reasonably argue there was prejudice in the sense that your client was on notice of what was at issue. The case was litigated for years, right?
Well, the summons, the rules of summary process, Rule 2D explicitly requires that there is a reason be stated. That's
the procedural history, I think, is clear that your client understood what the reason was.
Well, I don't believe that actual prejudice in a matter like this is required in terms of compliance with the rules of summary process.
You're arguing lack of notice. You have to show that you were prejudiced by the alleged lack of notice, right?
I would disagree, Your Honor. I cite a number of cases where notices to quit and evictions are commonly held not to be compliant because they're
That's
misleading.
in the landlord-tenant context.
But I think the same rationale applies here when we're discussing the rules of summary process. Again, I think the relevant point is that this eviction notice was incorporated into the summons. The summons itself, at one page, it requires that a reason be given for the start of the eviction case. The lender in this case did not need to do that. They could have stated, we're bringing this eviction based on a foreclosure, and that could have been their reason. They incorporated that notice to quit directly as part of the case. The most misleading language in that case is that it says in its own words, this notice is intended as a notice to quit pursuant to 239 Section 8A. That's the law for an eviction for no fault or non-payment of rent. That, of course, didn't apply here. This wasn't an eviction of that type, and then the notice in its own words stated that. And again, I'm not aware of any authority that states that actual prejudice is required for a flaw in the summary process summons or notice to quit. Again, we're not in a traditional landlord-tenant situation, but I would contend that the purpose is the same. Again, the bank chose summary process to obtain possession. It comes with responsibility. And one of that is very succinctly stating what the underlying reason is for the eviction. And in this case, where you have it incorporated a notice that had different reasons, and in its own words states this is the intent of a notice, when it never was the intent of a notice, I contend that they didn't comply with summary process. Doesn't state that they can't bring an eviction. What we're simply asking the court to do is to order them to do the process correctly. Unless the panel has any further questions, we would ask that the court overrule the housing court and enter possession in favor of my clients. Thank you, Your Honor.
Good morning, Your Honors. Peter Gaeta on behalf of Appellee MTGLQ. To pick up where my brother left, the notice to quit, the appellee's brief specifically jumps into that point and says, under the Morin case, which was affirmed under the Vickery matter recently, a couple of years ago, all that a former owner, all that a tenant in sufferance is required to receive is notice that that the foreclosing entity intends to take possession. And Morin and Vickery both point to the fact that at least the notices, the 244 notices, the publications, those are sufficient. This case is no different from that. I'll note that this former owner, this appellant, is not a bona fide tenant under 186A. And further, in my experience with foreclosures, and the brief requests this, a little bit of latitude is requested. Unlike a regular landlord-tenant situation where that owner who's rented to the tenants knows who's in there. Oftentimes we take these properties as we don't know who's in there. There could be a mortgagor and their son and then the son's girlfriend. And in that case, you need a 72-hour notice for the first two, and then maybe a 90-day notice after posting for the third one. So this gets a little complicated, and I believe that the Marinowski's firm's notice to vacate, as they called it, was trying to basically shotgun the whole thing. And in effect, it really doesn't matter now that we know that this appellant was the former owner and was a tenant in sufferance. Morin and Vickery kicked right in, and I would say I would say this appellant was aware of their intent to take the property as far back as the service members action. We know it goes as far back as at least the 244 notices, maybe the publications. That all gives them intent. So, spent a lot of time trying to figure out which avenue to go with first, whether we deal with the strict compliance or the standing issue. I believe that counsel left off with the strict compliance issue. The problem, as I was rereading Pinty and Marroquin this past week, and I realized that nowhere in those two do they actually define what strict compliance is. It's not until we get to Thompson, when they're answering the certification from the First Circuit, that they say, well, strict compliance means it's not deceptive, it's not misleading, and it's not accurate, it's inaccurate. And everything that the paragraph 22 requires, every warning, admonition, instruction that it requires is in there, and it is in there accurately, and it's not misleading, and it's not deceptive.
How is it accurate to notify, well, I'll leave out the question of whom for now, but to notify that you have the right to assert in the foreclosure proceeding the non-existence of a default when there is not going to be a foreclosure proceeding?
Okay, and I'll try to answer that question, but first I have to jump over to the standing part, which is that the first line of paragraph 22, the first line says, lender shall give notice to borrower, and the appellant was not the intended recipient of this letter. Unlike the statutory notices with public communication, unlike statutory notice, this was a non-public communication. Just because Ms. McIntosh got her hands on this document doesn't automatically grow rights in her. It doesn't grow right.
Well, I don't think anybody, well, maybe I'm wrong, and I don't need to say that. I think Ms. McIntosh owned the house, and she lived there. She's not a squatter. She's not a tenant. She was the owner of the home, who, due to, whatever the agreements were and the termination of the marriage and the divorce, ended up with the house, but not with the mortgage and the note.
She got the house in 2009, and the notice went in 2016. She had 7 years to arrange for this. As my brief points out, and that case by Judge Bowker points out, when you get a property by deed, you get the equitable redemption. That means you get to pay it off. There's no question, but you do not get contract rights. This is reinstatement. Reinstatement is what stops the foreclosure.
What do we do about the fact that Pinty says failure to comply with paragraph 22 renders the foreclosure void, not voidable, void. So that means title didn't pass lawfully to your client. Why would she not have standing to challenge?
Well, I did give that some thought over the weekend, Your Honor. Look at Pinty, Marroquin, and Thompson. Look at the litigants in that case. Look who would suffer harm by non-compliance, or look who the SJC sought to protect. All those litigants were mortgagors who who could have been harmed by reliance on misdirection.
I understand, and the argument has some common sense appeal to me, but you agree that the legal effect of a foreclosure being void is that title doesn't pass. Title did not pass to your client if the foreclosure is void, right?
There are a lot of reasons. I'm sorry.
Would you agree with that? That would be the legal effect of a void foreclosure?
There are a lot of reasons a foreclosure could be void. Most notably, usually it's the statutory failure to comply. Notices don't run 3 times in the newspaper.
But Justice Shin isn't asking about how it could be void. She's asking you about the legal ramifications of its being void. So if it is void, I understand you don't think it was in this case. If it was void, your client did not take title, correct?
If there were something which required the property, which voided the foreclosure property, then a foreclosure deed has no effect. But what I'm saying here is if statutory failure, that harms everybody. You forget to send the notice to the owner. You forget to send the notice to the juniors. The sale doesn't get notified in the newspaper. All parties with an interest or even interested in this property are affected. The only party who is affected, the only party who's harmed by any reliance upon a misdirection would be, in this case, Frank Costa. He's not here. She can't stand in his shoe. It's legally axiomatic, Your Honor. It goes back a long time in our jurisprudence that unless you're a third-party beneficiary or unless you have some type of authority to act on their behalf, You can't raise a contract. You can't raise that contract provision. She can't say that she tried to reinstate this loan or she failed to reinstate because of something we told Frank Costa.
How do we rule in your favor on standing without overruling Pinty, which we obviously cannot?
It's not overruling Pinty.
Okay, so
Pinty,
explain to me
Mariquin-
how we can reconcile finding she doesn't have standing with Pinty saying it renders the foreclosure void.
Pinty, Mariquin, Thompson did not envision this scenario. It was a non-borrower, non-mortgagee. They didn't reach this point. So leaving all that in place, leaving the Pinty structure in place, that yes, if this borrower were a mortgagor, then go right ahead, then go right ahead and void it. But Pinty stopped there. The SJC wasn't looking beyond that point. Now we have that issue. It's not exactly a novel concept, but it's mixed up in this. We know that a non-borrower or non-party to a contract can't enforce other parties' rights absent authority or third-party beneficiary. That's not novel.
So in your view, did Pinty announce a contractual right?
Well, Bailey, Hendricks, they dealt with challenges in 2011 and 2012. They dealt with challenges to the fact that the statutory provision wasn't done right, which is why all we need to do is show a foreclosure deed and affidavit showing that the sections 11 through 17 were complied with. 2015 and 2016 17 with Pinty and Mariquin was the first time that somebody brought before the court saying you got to get it contractually right. And in order to have standing, they couldn't have brought a tenant to that case and said, Your Honor, if Pinty were a tenant, Pinty wouldn't have been able to say, I didn't know how to reinstate. I didn't know how to raise challenges to the acceleration. I didn't know how to raise challenges to the sale, because that, as a tenant, they would, as a stranger to that contract, they wouldn't have had that right.
Well, back to the language of the notice. That's why I'm interested in the last clause or any other defense to acceleration, foreclosure, and sale. What if she wants to assert a defense that my ex-husband was supposed to be paying this mortgage, and that's her defense, but as written, it would look as though she has to assert that defense in the foreclosure proceeding and not in her right to bring a court action. Isn't that the problem with the way this is worded?
That's not my client's problem. What happens between these two, right? Acceleration is against Frank Costa. Reinstatement is from Frank Costa. That's between those two. If they're bickering who is supposed to be making the payment, who should be accelerating, that is of no consequence and no control by my client. My client laid out, if you read paragraph 22 and compare it with the requirements, that notice, everything is in there virtually jot for jot. There's an extra 13-word phrase, which, as I say, is not wrong, it's not inaccurate, it's not misleading, and in fact, you know, I'm doing judicial foreclosures now. I just got my first answer for a judicial foreclosure from a mortgagor. We can't tell in 2016 if the foreclosure...
If it's your first answer, then it clearly was not a common practice in 2016.
It's happened. It has happened, and I've cited a number of cases. It's allowable by the statute. Whether or not it's a common practice, it is allowable. Now, our clients can't tell through 2-3 years before the actual foreclosure sale whether myself as foreclosure counsel is going to say this one needs judicial, this one doesn't. This does happen. The new case, I cited to it, the new case, the Show Me case, specifically says that FHA juniors cannot be wiped up by non-judicial foreclosure, so you must go through judicial. So everybody who has a modification that resulted in an FHA junior mortgage when they took the arrearage and made it into a new mortgage, all of those have to do judicial foreclosures, and that's propped up in the last couple of years. This language isn't wrong. It doesn't meet the failure strict compliance. It's deceptive, it's not misleading, it's not inaccurate. We've given Frank Costa all the notices that he's entitled to, and then some, and they're all correct. And unlike Aubie, who was also a mortgagor, unlike Aubie, the biggest problem that the First Circuit Court had was with the and/or. I think, and I suggest to the court, that if Everything is in there. Unlike the egregious Pinty or Merrick when they just totally got it wrong. Unless there's something wrong, don't fall into the trap that the First Circuit has done in Thompson and Aubie and falling down the rabbit hole of
Even if we were to agree that the mention of the foreclosure proceeding did not render the notice invalid, what do you say about the placement of the last clause or any other defense? To me, the natural reading of that is that it is referring to the foreclosure proceeding and not the court action.
Well, first off, again, these are notices to Frank Costa.
I understand.
But secondly, and more importantly, it's all in there, in the and the order in which it's in, and the imposition of that 13-word phrase is about as dispositive as moving deck chairs.
You don't think the natural reading of the language matters? You don't think the natural reading of the language matters? I mean, the paragraph 22 requires notice that in the court action you can bring any other defense.
It's
and the
seriatim.
natural reading of this notice is that he had the right to bring any other defense in the foreclosure proceeding.
The language is separated by commas, it's seriatim, and the language that you speak of is actually after that first admonition that you can bring an action to assert
Oh,
the
it's not. It's after the second one.
But then it follows after the 13.
Well, right, and the end of it is
follows
also
14
after
words
this.
later, but it is after. Now, what does that intercession of a legally and factually correct statement do? Not much for this owner. First off, she didn't have the right to challenge the default or to challenge the acceleration, so it really doesn't do much. And I suggest to the court that, you know, this client didn't need to be told how to defend herself, and specifically not by my client.
She did because Pinty requires that the notice be strictly complied with.
To the mortgagor, absolutely. But my client had no contractual, no legal obligation to advise this appellant how to protect herself. And, as I've mentioned in the brief, she had no right to reinstate anyway. She had the right to redeem. That's part of the deed. She had no right to reinstate. She had no right to, and if she had no right to reinstate, she had no right to challenge the default. She had no right to challenge the acceleration. Wherever you move it, Your Honor, again, it's the placement of the words here is about as dispositive as moving deck chairs. If there are no further questions, Your Honor.
Okay,
Thank you, Your
Thank you
Honor.
very much. Thank you both. The case is submitted. We will take about a 15-minute break.
All rise. session, please be seated.
All right, our next case is Back Beach Neighbors Committee versus Massachusetts Department of Transportation, case number 2024P574.
Good afternoon, Your Honors. May it please the Court, my name is Michael Walsh. I represent the appellants in this case, who are also the plaintiffs below. With me is Mrs. Rossio in the gallery from the Neighbors Committee. We bring an appeal in this case from a Rule 12 motion in front of Judge Lang in Newburyport Superior Court. We offer a kind of a tangled mess of procedure following the demise of the counties.
The demise of what? Sorry.
Demise of the counties before the turn of the millennium.
I was unaware they had died. Maybe I'm the only one.
The counties have been abolished and some have been saved, primarily Franklin and down on the Cape and Barnstable, but Middlesex, Suffolk, and Essex counties as functional county governments have been abolished by Chapter 34B. The question that's before you today is what follows to their authority to govern roads. There is a road in Rockport called Granite Street that intersects with the street on which my plaintiffs live, called Beach Street in Rockport, and it is signed as a state highway, but it appears that the government doesn't know who owns and who regulates the street. As a result, the plaintiffs petitioned both the town and subsequently the Mass Department of Transportation, seeking some determination, a form in which they could be heard to present their complaints that the street is not safe, that it doesn't comply with the Massachusetts Highway Department safety guidelines, and the ilk. The petition to the Massachusetts Highway Department is the one that our complaint was appealing from, and that's essentially what's in front of you today. That's a little bit awkward because it comes in two postures. The first of which is that it substantively argues that Granite Street is signed as and is in fact Route 127 and therefore a state road and subject to state regulation. And the second is that in the alternative it is a county road. We argued there is one point I must argue that we argued below that, as my brother has pointed out in his brief, is moot, which is that we had argued under Chapter 30A, Section 4, that the Massachusetts Department of Transportation had failed to adopt mandatory regulations dealing with these types of petitions for rulemaking. We have since identified the requisite regulation, and therefore that particular argument, as I'm afraid, must be abandoned as no longer being fruitful. In terms of where we stand today, Your Honors are familiar with the papers, so I won't tell you anything that you don't already know. The most important part is that we see the county. We argued below and have argued in our brief here that the Massachusetts Department of Transportation conflates ownership of a road, the actual fee in the road, with the regulatory power over the road. And the regulatory power is what would give my plaintiffs the relief they're looking for, whether it be narrowing or closing or some kind of a traffic modification. The Attorney General's office offers two important related contentions. One is that this kind of petition does not result in a regulation. With respect, we disagree based on the specific exclusions in the definition of regulation under Chapter 30A, Section 1, which defines regulation very broadly to include any kinds of rates, restrictions, rules, regulations, or anything that's intended to have the force of law.
You're arguing that a regulation that specifically dealt with this one intersection, or a closure that dealt with just this one intersection is a regulation?
No, Your Honor, there's a regulation that deals with the length, access. Somewhere in the Department of Transportation, there's a register, and that register says all the roads the state owns and all the roads that come off of the roads the state road, because those are all the roads that are subject to the State Highway Department's Municipal Uniform Traffic Code under Chapter 82. And so somewhere in this table, this register, there is some kind of a rule that says Chapter 127 intersects with Beach Street and intersects with Main Street and intersects with other streets in Rockport. And that's the regulation we want changed. That is a general regulation. As to my brother's argument that a specific intersection doesn't apply, we also direct you to the carve-outs. The carve-out in the definition of regulation, there's one for public works, but it specifically carves out from a definition of regulation any regulation that is indicated by a sign. So stop signs, no left turn signs, those kinds of specific intersection intense regulations are not covered by Chapter 30A. But this isn't that kind of restriction because this is a regulation aimed at the entire length and width and the access points to Route 127 if it is in fact a state road. The other important...
Well, let's say we agree with you that Granite Street is a state road. What do you say to the Attorney General's argument or DOT's argument that this is a discretionary function? If the DOT decides it doesn't want to exercise its discretion to close this road, how can a court make them?
The answer to that, Your Honor, rests in the fact that while the remedy is definitively discretionary, our ability to have a forum in which to be heard is not. Our ability to ask them, to argue to them, to have them consider. Basically, Your Honor, the heart of that particular case is in our brief. It derives from a federal case called Flyers Rights Defense Fund versus the FAA. And it's a case where the FAA was asked to adopt rules governing passenger comfort. And the FAA had found that they had no jurisdiction to do so based on the fact that their regulatory authority dealt with safety. And the DC Circuit found that even though safety could be a broad and spongy term, that at least the plaintiffs weren't necessarily entitled to a remedy for their rulemaking petition, but they were at least entitled to be heard. And that's why there's a section in our brief which distinguishes very sharply between a no and a no jurisdiction. And so as a result, the remedy is definitely discretionary, but in terms of our ability to get to a forum, Your Honor, that's something that we do have the right to, at least the ear of the government. My brother also argues that I have, in relation to the demise of the county, is between Chapter 34B, Section 4, and Section 6, sort of conflated. And the language is opaque because it says all county roads are hereby given to the state, and then all of those roads are given to the towns in which they are, unless there's confusion about where the road is, or unless it's one of a very long list. We struggled with that, and it was kind of opaque to us. But we found one of the things that's not in the brief that I must direct your Honor's attention to is Chapter 81, Chapter 82, Section 1. This is immediately before the county petition law, Section 2, under which we had hoped to proceed. And this says that in counties where there is no longer a county and there is no successor government, there's supposed to be a created county commissioner board that will continue to exercise all of the county commissioner's regulation functions. And that commission, that regional adjudicatory body, is supposed to be headed, established, and run by the Massachusetts Department of Transportation. The answer, Your Honor, is that we didn't know exactly where to go, but we went to the Department of Transportation, and they are supposed to know where to go. And whether they shunted us off into the county track because they thought that's where it belonged, or the state track, that was something that we would have been happy with either. But the reason that we seek mandamus relief in this case is because, Your Honor, nothing happened to the petition. It just stayed there. We didn't even get a letter acknowledging that we'd sent it. We didn't even get a thank you, but no. We didn't even get a brush off in a single-page letter. We appreciate your concern. I wrote to the White House when I was 6 years old, and I got a single-page letter and a President Bill Clinton. It's not particularly engaging, but at least it's some kind of right that you have been heard by your government, and none of those happen here. And that's no small thing when you're talking about what we contend are ministerial rights that we are entitled to at least be acknowledged and to be heard, even if not to be granted relief. In relation to the county road, it is significant that these adjudicatory panels exist under Section 1 because that means, as I have argued in my brief, that the fee ownership in the road is materially different from the regulatory authority, and therefore, whether we were...
Which road do you mean?
Granite Street, Your Honor.
Okay.
And so in relation to the road, we should be entitled to engage the government's regulatory authority wherever it's held. There is also a typo in Justice Lange's decision. He wrote in his decision that we had submitted in our 12B motion minutes from the Board of Rockport where the road was called a town road. He should have written where it was called a state road. And that is somewhat material to our argument because, as Justice Lange noted below, we have been whipsawed between these various government agencies that don't know who owns the road or who regulates it or who funds it or anything of the ilk. Somewhere in the administration of government, these are all controlled based on things like Chapter 90 money and who plows the road and things like that, but it's material in terms to us as petitioners because it determines our form, it determines the kind of relief we're entitled to. If this is a county road, our position is much more superior than if it's a state road, because as a county road, as long as we're willing to post bonds and do other things to ensure that we're not wasting the government's time, we're entitled to a very relatively formal court-like process that's been on the books since the early 1600s, Your Honor. In terms of whether this is a state road, which the state denies, then even though it may be signed or not, or maybe the signage is different from the jurisdictional ownership, the important question under a state road is whether or not we're still at least allowed to make our petition and have it acknowledged, even if this, there's a follow-on argument that I suspect makes my argument have a little bit more kick, which is that in addition to Chapter 30A prescribing against government inaction or allowing mandamus to compel against government inaction, we also believe that this should follow a series of cases, and the lead federal case that we cited that we're hoping to import into Massachusetts administrative law is the American Horse case. But it essentially says is that when you're dealing with petitions for rulemaking, the government doesn't have to say yes. But if they don't say yes, they should have some reason. And the reason needn't be anything more than what we have is already working or there isn't sufficient damage.
So are you saying that the petition to DOT was a petition for rulemaking?
Yes, Your Honor, it was
And what
captioned
was
as
the
such.
language of the rule that you sought to have them institute?
It was captioned as a petition for rulemaking. There was no draft regulation to accompany it.
Wasn't that required?
It would appear to be required under the regulations that we have since identified, Your Honor, although I argue based on the text of another provision of the regulations that we have in substance complied with the existing regulations and therefore should be entitled to some version of an answer.
Well, there's no text of a regulation in the petition. In fact, the petition doesn't say rulemaking or regulation.
I may be confusing it with the petition to the town, Your Honor, but it cites to Chapter 30A, Section 4.
Well, it says
and is a
the
rulemaking.
committee requests a hearing either under Chapter 82 or Chapter 30A for their petition to end vehicular access from Granite Street to Beach Street and vice versa. So that single reference to 30A was enough for the committee to get all of these rights for rulemaking, et cetera?
Your Honor, it's not just a stray matter. The committee hired counsel. They went to both the town and the state. There was a rather lengthy, there was an extensive history about research. Believe it or not, one of the objections that we had made in the first section of our brief was that Justice Lang had failed to credit our facts that this is either a county road or a state road, thus there is some kind of state jurisdiction. And in failing to credit that, had we been entitled to that inference, should we be called upon to prove it, we did research. We have documents from 1838 about a county petition from a gentleman named Azor Knowlton to establish the road. We have an 1872 work order from the county. We could have proven our jurisdictional claims had we been at least given the form in front of the state, and we weren't. And that is essentially the crux of our argument, that we've essentially, as citizens seeking to better the world, or at least our little piece of it, haven't even been given the courtesy of a brush off. We've just been ignored. And whether you take it as a state road or a county road, we don't think that makes a difference. We think that there's enough here between Chapter 30A and Chapter 82, Sections 1 and 2, that we were entitled to some kind of a form, maybe not a hearing, maybe just on the papers. But we didn't even get an acknowledgement. As the complaint pled, we got a very polite phone call from a paralegal in the General Counsel's Office of DOT. They didn't even send us a letter saying thanks, but no thanks. And respectively, Your Honor, when you have, as Chapter 38, Section 4 says, when you're supposed to have regulations, that a formal process that deal with the consideration and disposition of petitions for rulemaking, we shouldn't have just been brushed off. And that, respectfully, is the crux, gist, and whole of our argument. Beyond that, we very much wish the court to pay particular notes to the Flyer defense case. It is not, Massachusetts administrative case law is not quite as robust as the federal government. I do cite to a case that we follow the federal rule unless there's reason not to. The federal rule envisioned in Flyer's defense, American Horse, and also cases like Portland Cement generally stand for the idea that whenever the government does something, it should do so on, it should have a reasonable basis. It shouldn't be arbitrary or capricious. That rationale has been used in the federal administrative case law to extend the reach of administrative law somewhat far. For example, even when the government chooses not to do something, if it relies on studies, it's obliged to disclose them. And we believe that this should be a feature of Massachusetts administrative law.
One of the grounds for relief that the plaintiff sought in the Superior Court complaint was for the Superior Court to order the removal of non-compliant angled parking on Beach Street and in-lane parallel parking where the road's not wide enough. Now, this is on Beach Street, not on Granite Street.
Yes, Your Honor.
And this was in this Superior Court lawsuit against DOT.
Yes, Your Honor.
I don't read in your brief that you're pressing those arguments on appeal. Judge Lang, as I take it, said that the only relief sought was to close the northern access point between Beach and Granite Streets.
Yes, Your Honor. We had argued to Justice Lang, based on the structure of the laws, that closing the road is the nuclear bomb of road regulation and that all of the lesser road regulation follows. The reason we're talking about Beach Street is because there is a rule against angled parking unless a list of criteria can be met. It's in MassDOT Safety Manual. MassDOT Safety Manual only reaches state roads, roads subject to the jurisdiction of the state, or roads leading to or from a state road. And there's no doubt that Beach Street, which is where my clients live, connect to Granite Street. So the question is whether the state There would be another lawsuit following this if I successfully established that there was some kind of state jurisdiction, even if they told me to go pound, that would allow me to apply rules against things like angled parking. But that, I'm afraid,
as I understand it, you just had a trial in the land court?
We had a trial in the land court arguing over who owns the fee in Beach Street, but it does not touch Granite Street, Your Honor. We offered to the judge, Judge Vey, the opportunity to delve into the Massachusetts Department of Transportation's parking guidelines to deal with angled parking and whether or not Granite Street was a state road. Or
so we're not dealing with the angled parking or the fee on Beach Street in this case?
We are not dealing with those in this case, Your Honor.
Okay, thank you very much.
Thank you very much, Your Honor.
Good morning, Your Honor. Samuel Hershfang for the Massachusetts Department of Transportation. At its core, the plaintiffs are seeking to compel the department to respond to an invalid petition under the authority of Chapter 30A, Section 4. That is an invalid approach by the plaintiffs for several reasons. One is that the original petition does not invoke Chapter 30A, Section 4. It relies solely on Chapter 82, Section 2, which is the no longer applicable requirements for right to petition county commissioners. The second reason it's an invalid petition is because it does not, as Your Honor pointed out, it does not mention or an actual regulation that it wants the department to promulgate. And the third reason that it was invalid is that the relief that it seeks is not regulatory relief, that this one-off effort to close off one road does not amount to a regulation. So on all those reasons, they cannot succeed. This is the first time I've heard of Chapter 81, Section 1, frankly. It's not in the brief. It wasn't argued below as far as I know, and it's, I would argue, waived because we never had an opportunity to address it below or in our appeals. Other than that, Your Honor, it's pretty clear. The text of the regulation that MassDOT does have with regard to the petition power is that it does not need to respond to any petition. As plaintiff acknowledges, they did in fact respond informally and then told them that they weren't going to act on it, but MassDOT wasn't even required to do that because what they submitted was not a Rule 4 petition, a Section 4 petition. It was a petition under Chapter 82, Section 2. So there was no need for MassDOT to do anything at all. It was simply an invalid response effort to get some kind of response from MassDOT. And in any event, if that wasn't a sufficient response, the response to the litigation we have now would amount to a response from MassDOT that it was not going to be taking any action on the petition. So MassDOT complied with all that it was required to do under the circumstances, and the plaintiffs did not properly and could not, I would argue, raise a Section 4 petition for the kind of relief that they were looking for under these circumstances. At best, they could do a petition in the broader sense, which is how MassDOT treated it. They treated it as an inquiry from the community about something, and it responded informally to an informal inquiry. And that was all that they were required to do. Again, there was no language that was required under the regulations that require a specific language of statute, of the regulation. It didn't appear. And so there was nothing further that MassDOT was required to do. Unless any other questions from the court?
I see none. Thank you very much. Thank you both. The case is submitted.
Thank you.
Okay, our last case is Department of Children and Families and Others versus Father and Others, number 2024 P712. And this case is impounded, so please refrain from using the parties' names. Do we have everyone here? No. So I'll just mention again to please refrain from using the parties' names because the case is impounded. Do we have an agreement on the time split here?
I believe, Your Honor, that 555 is acceptable to everybody.
Okay, and your attorney for the mother, you're arguing first?
Yes, Your Honor. That was changed up.
When you're ready.
Thank you. Good afternoon, Your Honors. May it please the Court, my name is Joan Altimore, and I represent the mother in these proceedings. This case is replete with violations of mother's due process rights as to her appointed representative, being without counsel during critical hearings and being forced to retain counsel not of her choice. Forced representation is not effective representation and is a violation of mother's constitutional rights to due process. At all times during the proceedings, mother requested, first, that her appointed counsel be replaced, second, that she be allowed to represent herself, or third, to have the father handle her representation. Each time, each of those requests essentially was denied by the court. In terms of 3 counsels were appointed on her behalf. The first handled the temporary custody hearing. He then withdrew. The second counsel was appointed and then withdrew due to health reasons. At that point in time, several hearings then continued without mother having representation. Trial strategy was discussed by the judge during that point in time. The third counsel who was appointed, at all times mother asked for that counsel to withdraw and for her to be allowed to represent herself. I would say probably at least 3 times, if not 4 times, especially during the trial, the third counsel did request to withdraw. She was not allowed to withdraw until the conclusion of the trial and until after the decision was made, and then her withdrawal was accepted. At this point in time, mother continues to not have trial counsel.
You mentioned the mother's, I think you said, constitutional right to represent herself. Where do you find the basis? What is the grounding of that right in the law?
Thank you, Your Honor. The Sixth Amendment says that a person
This is a civil case.
Understood.
So the Sixth Amendment does not apply.
Correct, Your Honor. And in fact, on the federal level, I cited the case Ferretta, which states that, which is a criminal case, not a civil case. And Ferretta basically said, Ferretta says, can you force counsel upon a defendant? And the answer was no.
And that's in a criminal context. And Ferretta was then criticized by the Supreme Court in Martinez, a later criminal decision out of the United States Supreme Court that said, probably a little more politely, Ferretta was running amok with this reification of the right to self-representation.
I draw your attention, then we go to, again, another criminal case, but Commonwealth versus Means in Massachusetts.
What's your best legal authority for saying that someone has a right, either constitutional or statutory, to represent themselves in a civil case?
Your Honor, that is a very good question. And what a lot of the care and protection cases that have come from this court as well as the Supreme Judicial Court talk about at what point does a court have the right to say you're no longer entitled to counsel, that you forfeited your right to counsel. And Means talked about
I'm not talking about forfeiture, I'm talking about right.
No, and that's my point, Your Honor. I could not find, and maybe I'm wrong, and I could not find that case in a civil proceeding which says you do have a right to represent yourself. That's why I draw the analogy to Means, where it is a forfeiture case in a criminal proceeding where that defendant asked, after his counsel had been withdrawn, well, not withdrawn, struck, that they then said, we need to do an examination.
Well, but the criminal cases all talk about if a defendant represents himself and is competent and does so foolishly, he's basically sinking his own boat, which is the lifeblood of the law. It's his right to do so. But this is a civil context where we have children's rights that we have to think about too.
Correct. And in Valentina, it said, a judge must balance the interests of the parent with the child's interest in finality. But the point is, for this particular case, where the judge, I believe it was the initial judge, because there were, I believe, 2 judges who handled these proceedings. One who did the initial stage of the case and one who did the trial of the case. The initial judge said, when mother requested to represent herself, the judge said, let's assign a court clinic to do an evaluation on mother's ability to represent herself. But the court clinic report, which was issued on November 2nd, I believe it's 2022, was framed as, and it's attached as an exhibit, I'm sorry, I don't know the exact number off the top of my head, came back as this is an evaluation as to the competency of mother to proceed with trial. Not about whether she could represent herself, but what's significant in that evaluation is that it said, I don't believe that mother is competent to participate in this trial. And that's significant for a number of different reasons. One, it doesn't talk to the original question, is she able to represent herself? But 2, once that report was received, the trial judge then relied on that report to continually deny mother her request to represent herself. In fact, there was a statement by the judge.
I'm going to let you finish your thought, but your time has long expired, so.
Oh, I'm sorry. And so the point is, nothing was ever done with that competency evaluation by the first trial judge or the second trial judge to see whether or not mother actually understood what these proceedings were. And that is a violation of her due process rights. If she's not allowed to represent herself, then is she getting effective representation otherwise?
Okay, thank you.
Good morning, Your Honors, and may it please the Court. Attorney Kyla Clay on behalf of the appellant child. Before I begin, I would like to note that I am filling in for Attorney Amy Mercier, who has been and continues to represent the appellant child. As I was recently appointed for purposes of this oral argument, I did not write this brief, but I will do my absolute best to answer any questions you have. My client is a 13-year-old boy who, despite the last 4 years in foster care, wants to return home. He's respectfully asking this court to reverse and remand the trial court's decrees determining his parents' rights because fundamental due process violations deprived his family of a right to a fair trial. For purposes of today's argument, I'd like to spend my time addressing the trial court's failure to properly consider mother's competence to waive her right to counsel, which ultimately deprived mother of her constitutional right to conduct her own defense. Now, to kind of go back to the questions that this court asked earlier, with regards to the Ferretta versus United States case, Ferretta versus California, that case talks a lot about how the right to self-representation is grounded at the very beginning of our country. It's been one of the hallmarks of our legal system since the start of our legal system here. And furthermore, Department of JKB also talks about the right to counsel in these care and protection proceedings. And we've also seen that courts have allowed forfeiture and waiver of counsel in other cases in care and protection proceedings. So with that, I believe that there's strong precedent to say that parents do have a constitutional right to represent themselves.
Well, Ferretta was grounded in the text of the Sixth Amendment. Right?
Yes, the Ferretta was grounded in the text of the Sixth Amendment, but
so where in the text of What constitutional text are you relying on to derive a right to self-representation in a civil case?
So FARETA is rooted in the Sixth Amendment, but FARETA also talks extensively about the history of our legal representation system and the history of the United States believing that self-representation is essential to all defendants.
And then later in Martinez, this court said it doesn't extend to appellate proceedings. So, I mean, there are limitations on what even FARETA said.
Well, there are definitely limitations on these rights. The fundamental right for a parent to represent themselves in these proceedings must apply because we've had cases that have specifically said that the deprivation of one's child is just as onerous as the deprivation of one's liberty.
But it seems pretty clear that at least under federal law, there's no constitutional right to self-representation in a civil case.
Well, I would argue that when a parent is not allowed to represent themselves and they're actively asking for their attorney to be removed, that does violate their constitutional right. They have a constitutional right to the effective assistance of counsel, and they have a constitutional right to represent themselves. And if they're not receiving the right to effective counsel and they're asking for a different attorney, then the court
Where is the right based? Which provision of the Constitution?
So I would argue that even though the right is not based in criminal rights, we have cases like Department of JKB that have specifically said that we will apply these types of criminal holdings in cases involving parents and children because of the very severe risk of losing their child. So I believe that right should apply to parents here. And in this case, the court failed to consider whether mother was competent to waive her right to counsel. The court instead focused on whether mother demonstrated skills generally associated with representing oneself. But that wasn't the question in front of the court. The question was whether mother could voluntarily, unequivocally, knowingly, and intelligently waive her right to counsel. And that wasn't considered by the court. We see that in the court clinic evaluation that they talk about how it would benefit mother in the process if someone were to take time to educate her about the legal system.
If a police officer were interviewing mother in the course of a criminal investigation, and she said some of the things that she said in this competency evaluation, I don't know what's going on, I don't know, my husband knows. Do you think that a police officer could lawfully think that she waived her Miranda right to counsel if she answered as she did there?
No, but I think that that's different because in this case, mother, a lot of the difficulties here was mother's communication and the lack of an interpreter that could help her with communicating effectively. So for some of the things that mother had said, I don't think that would apply in the case of Miranda because she wasn't given an opportunity to, fully communicate.
So your time has expired. I think we're going to have to
Honor.
leave it there. Thank you very much.
Thank you.
Good afternoon, Your Honor. I'm father's appointed counsel, but not by his wishes, Margaret Geary. He has been sending urgent messages to the clerk's office this morning, reiterating what he said on Friday, just to let you know. Commonwealth versus Means has been applied to care and protection cases. This court, in fact, applied it in adoption of ULON, which was an unpublished case before you started publishing the 128s. I think since then, Means has been applied to care and protection cases. So the right of self-representation, constitutional right, is actually in the case law already. I didn't look it up. I just made an assumption since Means says the flip side of having a lawyer is having the right to waive a lawyer, and that has been applied in care and protection matters.
So there is a Massachusetts statute, General Laws, Chapter 221, Section 48, that says parties may manage, prosecute, or defend their own suits personally.
Right.
Or by such attorneys as they may engage.
That's correct. But
That's
it's
a statutory right.
It's a statute, and if there's a violation of the statute, then the court's going to look at, well, what was the harm, and was it harmless error? That's the standard for statutes. The constitutional standard you end up with a void judgment if the error's been made. So I'm aware of the statute, but I'm also aware it didn't do anything for me in this case, because at the end, you'd be looking at the conduct of the case as a whole.
And I agree with you that both Means and then Martin talk about how the constitutional right to counsel applies, or the right to counsel, sorry, I'm going to start over. Both Means and Martin say that in both criminal and civil cases, there is a right to be pro se. Each of those cases obviously is a criminal case. Why they're talking about rights in civil cases is somewhat unclear to me. But have you seen a civil case, or can you cite to us a civil case? Particularly, I'm interested in one in this context, a family law case, saying that a parent has a constitutional right to be pro se, where not only their own parental rights, but also obviously their rights and the upbringing of the children are at stake.
Yes, and in fact, it was this court, it's an unpublished opinion, it was this court, I think it was last year, it was a case out of North Adams, and the mother, I was representing the mother there, and she, I brought up Commonwealth versus, I think it's Halterwanger. I said, I don't think this woman's in her right mind. And the judge did a colloquy, and the judge found that she was competent to represent herself, even though she was having visions in parking lots and so forth. I'm pretty sure that that's a rescript. It came down last year, and
you don't remember that
probably cited other cases.
Number, okay.
What was the name of it?
Well, I remember my client's name, but I don't remember the pseudonym of the
Oh,
case. I can look it up and send a letter afterwards. I'm sure I have it on my phone somewhere. But I think the point I wanted to make in my 2 minutes left is, if I came in here and said, Father was so annoying, I was not able to file a brief, I don't think any of you would excuse me. We have a whole set of laws, we have a whole set of regulations and court practices that should be applied in all cases. And if somebody comes in like Father, who's a well-known, I guess, vexatious litigant, and the court had experience with him before, what would have been, why is it not manifest error for the court not to apply Means and go through the colloquy that's very expressly contained in Means to have him waive his rights or find grounds where he's not going to be allowed to waive his rights? Because Means applies to these cases since, 15 years ago. And people are allowed to represent themselves, and when they do, this court holds them to, the same standard as anybody else.
So Means is a case about forfeiture of the right to counsel, right? And
however, it does have the steps that you need to take to warn people they're going to forfeit their right, and if they want to waive their right. I think it's all in Means, and I did lay out most of it in part one of the brief.
So your position is that the flip side, that what your client is asking for, which is to exercise his right of self-representation, should be analyzed the same as a forfeiture case, or that the process he is due is the same process due a defendant in a forfeiture case?
And I think it's in that case that I'm going to look up for your honors from last year out in North Adams, because it was certainly held that that woman had a right to represent herself, and the judge did a colloquy because her trial counsel didn't think she did. I was standby, didn't think she did, and that's how it worked out. The other point I wanted to make, which I guess I don't have time to make, is if your honors look past the noise that Father's interruptions and so forth made, I think you'll find that there is very little to no evidence of unfitness in accordance with the case law. I went through it carefully.
Sorry, I want to stay for a moment on the competency question, because there's one you mentioned, Halterwanger, and that case draws a distinction between competency to stand trial and competency to waive counsel.
And represent yourself, yeah.
I don't see much in the record of this case that draws that distinction. Is it your position that the competency evaluation that was done of your client had to do with his competency to stand trial or his competency to represent himself, or both?
It's unclear. I think the point I'm trying to make is that absolutely nothing was done in accordance with the standards that are set forth in Means. Father said, I want to represent myself, and the judge literally said, no matter what it says in the court clinic evaluation, we're not going to do it. He never had a hearing. He never had a right to present evidence about his right to represent himself. All of the procedural safeguards that were there to protect him were not engaged in. And I assume they were not engaged in because he really is a troublesome guy and it creates a lot of chaos in the courtroom. But the judge handled that courtroom just fine. I don't know how much worse it would be if he was representing himself than it was in any case, because you didn't have him shouting over his own lawyer saying, no, 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 which I assume would be happening here this morning if he weren't on the YouTube feed instead. So he was treated badly, but more importantly, I think the attitude with which he came to the court and the court had toward him because of all their previous dealings didn't allow them to see that there was really no case against him except for the fact that he's annoying. The school says he's indoctrinating his children to fear DCF, and my response to that is, so what? And nobody from the school said his children weren't being educated, or indeed how he was interfering with their education. They just didn't want to have to deal with him anymore.
Okay.
And that's what started this ball rolling.
Your time has expired. Let me just make sure there are no questions. Okay.
Thank you.
We're going to have to leave it there. Thank you very much.
Good morning. I believe I was going to have 9 minutes.
9 minutes. Okay. Thank you.
Talk fast.
Members of the panel, may it please the court. I'm Kristen Braithwaite, Assistant General Counsel for the Department of Children and Families, and I'm here today asking you to affirm the decree issued by the lower court. The evidence put before the court of both mothers and fathers' unfitness was overwhelming, and the court properly determined it was in the best interest of the children to terminate parental rights.
Do you agree that the parents have a constitutional right to self-representation?
I do not. I agree that they have a statutory right to self-representation. I agree that I believe that there are a number of factors that have to be met to entitle them to self-representation in the case of a care and protection.
And where do you find those factors, or where might we find them?
So there's two separate sets of factors, if you will. The first is that a party in a care and protection matter may waive counsel only when such waiver is voluntary, unequivocal, knowing, and intelligent. And I believe that's in adoption of Raisa. It may also be in adoption of Olivia, which says a decision on a motion to change counsel is committed to the trial judge's sound discretion. But I would also point the court, with regards to adoption of Raisa, to another element that's required in order to waive counsel, which is that the court is entrusted with the obligation of ensuring a trial moves forward. The best interests of the children are at stake. So in order to waive counsel, the parent has to have an awareness that there are technical rules governing the conduct of a trial. And adoption of Raisa holds that it is proper and a judge has broad discretion to take reasonable measures to keep the proceedings moving forward, even if the result is, in the case of Raisa, to leave the parent without counsel. In this case, it would be to leave the parent with counsel over objection. So I would point to Raisa as the primary grounds.
And what is your response to my not very good question about what, if anything, was the point or the outcome of the father's competency assessment?
The father's competency assessment was that he was likely competent to proceed with trial, but that he was not familiar with what would aid in his defense. He would require support from the court as a gatekeeper to know how to best advance his case. I would also point this panel in the competency report for father to his indication that he himself did not believe he was competent to represent himself. He says explicitly to the evaluator, I require a lawyer. And the judge was not of the opinion, the transcript as I read it was not the judge saying, I disregard the competency evaluation. The judge was saying, that is a part of the puzzle, and there is also my own observations, which she was certainly well within her rights to refer to. So the competency evaluation, you have father an indication that he doesn't understand how to advance a defense. You have him indicating he requires counsel, and then you have the
Standby counsel, right?
No, he said he needed to be represented by a lawyer at the time of the evaluation. He later indicated a preference for standby counsel. That said, when he detailed what he wanted that lawyer to do, it was to support him. He felt he could articulate his case, but that he needed a lawyer so that it would be done in conformity with how a trial would work. But I think most compelling to the court's determination that father should not be permitted to represent himself was the court's finding that father's thinking was not grounded in reality. And the case law in the Commonwealth is clear that a trial judge may rely on his or her own observations.
Those findings were made in the final decision, right?
Correct.
So how is that relevant at the time when the judge denied the motion to represent himself?
Well, similar findings were made in the courts. So the court had two sets of findings that were issued in response to father's motions for the right to represent himself. And in fact, those even came before a single justice who found that the judge did not abuse her discretion based on her findings. I would even argue that as to father's claim, res judicata would apply here, given that father did not appeal the single justice's finding that there was no abuse of discretion as was authorized by the statute. But that said, I think that the findings themselves with regards to father's right to represent himself did focus more heavily on father's inability to follow the procedures of the court than they did on his competency. But in the Commonwealth of Massachusetts and in care and protection proceedings, both are legitimate grounds upon which to find.
So if this was a criminal case, would you agree that these would not be sufficient grounds to deny a request for self-representation?
I would be speaking beyond my competency to say what I would find, but it would certainly be a different analysis.
If this was a constitutional right, it wouldn't be sufficient to say, well, it's going to delay the proceedings, right? That wouldn't be a sufficient reason.
I believe that it would, but my hesitation is because that's not the area in which I practice, and in child welfare, the best interests of the children are so paramount to keeping a trial moving forward. And so it's just such a different analysis that I'm used to. But I fully acknowledge that were this a criminal matter and were this a constitutional right, the analysis would be quite different.
So if it's just a statutory right, so how do we determine whether the judge properly denied the statutory right?
Well, as I indicated, there were two motions brought before the judge, and she issued detailed findings. So she didn't just deny in the margin. So I think we know what her thought process was. The abuse of discretion standard is what would be used. As I said, a single justice here has even found that the trial court did not abuse her discretion. And she pointed to clear evidence that father, even when he would indicate support or respect for a court rule, would then find himself unable or unwilling to comply with that rule. And she found that this case could not proceed were father to be representing himself. And I think it's also important in the context of this larger discussion to note that father was not silenced. Even though he had counsel at the end of every matter, father was given an opportunity to speak freely. So this wasn't the case of a judge saying, father's difficult, I don't want to hear from him. As I know your honors are aware, another element here is the Commonwealth has held, and I believe it was in the context of a criminal case, that trial judges have a special protecting duty. So when someone with a mental illness seeks to waive their right to counsel, trial judges entrusted with ensuring that that is done in a way in conformity with the actual understanding of the rights they're giving up. And here the court clearly did not find that to be the case. And that does circle us back to the competency evaluation, which found that while father may be competent to stand trial, he doesn't understand what elements of information are actually in his best interest to present for the defense. So the court was able to ensure that father had adequate, competent representation and also gave him his opportunity to speak. Because again, at the end of every proceeding, she did offer him an opportunity to speak uninterrupted so that he could say whatever he wanted to say to the court.
I feel like we should have more questions.
I'm happy to answer them.
We don't really seem to.
Is there anything else you wanted to say?
No,
50
I
seconds
would just say that at the crux of this case is not really the issue of waiver. It's 3 special needs children who spent years living in fear and isolated from the rest of the world. I think the evidence was overwhelming that the parents' rights being terminated was in the best interests of these children. The record demonstrated that the judge was thoughtful in applying the information before her to reach her conclusion, and I would just ask that this panel affirm the decrees issued by the trial court. Thank you very much.
Thank you.
Good afternoon, Your Honors. My name is Warren Yanoff, and I represent the eldest child who was once known as Dorita in a previous case, also a pseudonym. It's my client's position, and she articulated it was one of the unusual situations in which she actually did testify in this case as to her desires when she was 12 years old. She's now 15. The issue is she wishes to be adopted. She has affection for her parents, but she has been de-stressed, if you will. They thought she had autism. She has pervasive developmental disorder. But the fact is, even at the time when she has been in foster care, she was getting A's and B's in class. She felt less stressed. She has friends. She was functioning. I think what has not been addressed is the judge's findings of parental unfitness are not challenged in this case, and that the judge's conclusions were amply supported.
Well, they are challenged. What do you mean they're not challenged?
Well, not specifically. They're challenged in a
subsidiary
general context.
findings. I see. Okay.
But that the specific findings relative to the fact that there was truly non-compliance with the service plan, non-compliance with the department, is really overwhelming in that those are bases for determining whether parental rights should be terminated. And in this case, regardless of whether parents chose to be represented or not represented, the facts of this case are they didn't work with the department to correct those issues. And as a result, my client purely articulated the desire to be adopted, not just to not live with the parents, but to be adopted. She would have a right, given her age, to deny any adoption, and she has chosen not to. She has chosen that she wants to see her parents, have contact. It's been not very, even during the trial, not very consistent. It's only been video with the father, but she was traumatized by told that DCF would rape her, that they would kill her under certain circumstances. She was told to lie. She is free from that. That's how she expressed it. And to that extent, Your Honor, the judgment should be upheld.
Thank you.
Thank you.
Good afternoon, Attorney Kling. I represent Daniel on appeal. He is, of all of the children, the most affected by autism. And this idea, I just wanted to address this idea that really this is all based on him just being difficult. It's more than just that, Your Honor. This is a young child who could have gotten a number of services in that home prior that were repeatedly denied by the father. For example, they were offering PCA services for all the children, or PCA voucher, $500 per child, to the family when it wasn't what he wanted. He denied it. There was an opportunity to put in a fence in to keep this particular child in the yard because he had wandered off into the neighbor's area at least 3 times and that, again, was denied because it didn't meet his specifications. There was Boston Children's offered a service that was denied because, again, it didn't meet his specifications.
When you say his specifications, you're talking about the father, not
Correct.
about your client.
And so there was a number of instances like that when the department was attempting to work with the family, not keep these children in the home, where there were repeated services denied, because it didn't match exactly what he wanted. And this child, by the time that he was removed, was really, by the parents' own admission, they couldn't control him. There was aggressive behaviors, there was a number of things that were going on. And so I would suggest that this is not about, just wanted to address that point of whether this was about really a difficult parent. This was more than just that, at least as to his perspective. There was a number of services that were refused. And in fact, at the time that he was finally removed, there was a recommendation made, and it's in the record, that either he be in a residential treatment or in a situation where he's in a specialty school. And as to the rest, I would submit on the brief, Your Honor. Any questions?
Thank you very much. Thanks to all of you. I know 15 minutes is not a lot divided among 3 parties, but we have your briefs and we will give the case thorough consideration. The case is submitted. That concludes our session. Thank you to the court officers, clerk's office, and our timekeeper. We are in recess.
All rise.